does not have such details,
No, my lords.
isn't it?
Please.
Now, what is the other office objection?
The typed copies of annexures, my lords. It may be kept in abeyance for the time being, my lords, since there's urgency.
The other office objection is kept in abeyance for the present.
My lords, I've filed I'm before your lordship challenging the order passed by respondent number 2 at annexure A, my lords. DC's order. If I may take your lordship to annexure P at page 77, which reflects a village map. There are two blocks, block number 3 and block number 4. Block number 3 is the property of Mr. Salah Saab, from whom the title has flown to respondent number 3, my lords.
Now, what are you challenging?
DC's order, my lords. My lords, the crux of the matter is respondent number 3, in each sale deed that has been executed, the measurement of his property clearly reflects 100 into 60 feet, my lords.
Yes.
But the impient survey sketch at annexure M declares that the respondent number 3's land measures 175 into 30 feet, my lords, which is confirmed by the DC's order, who is respondent number 2 here in, my lords.
Now, before the deputy commissioner under 56, is it?
Please, annexure A.
59B, second appeal.
Please, my lords.
Second appeal.
Please.
So the deputy commissioner rejects.
Deputy commissioner, my lords, based on the survey sketch was issued in 2009, my lords. After survey sketch, the respondent number 3 gets his property by the sale deed at annexure N.
What happened to the order at 49A, first appeal?
First appeal, the AC Assistant Commissioner rightly rejects the respondent number 3's request to change the khata in his name based on the survey sketch, which predates his sale deed, my lords. It was rightly held, and it is not a revenue property. So it rejects, and this is a Manedala Chiti land. The Panchayat has got the powers to settle the disputes when it comes to Manedala Chiti, and it has rightly held that the AC's order, which is at annexure B, my lords. This was again appealed by the respondent number 3 at annexure A, the DC's order. The DC respondent number 2 herein rejects the AC's order. Meanwhile, with regard to petitioner's rights, the respondent number 2 asks the petitioner to approach the civil court, my lords.
In light of the contentions raised that the order of the Assistant Commissioner had rightly rejected the petition of the private respondents while observing that the measurement was already made in the year 1958-59.
Please, my lords.
58-59, and such order ought not to have been interfered with by the Deputy Commissioner. There would be stay of the order of the Deputy Commissioner at annexure A. AG accepts notice for the respondents 1 and 2, emergent notice to the third respondent.
Obliged.
Question number 34. Reason for second time.
Look for the petitioner.
Yes.
The officers raised the objection, my lordship. The Karibasuf was not made a party. He was died on 7/1/2019, madam.
In light of the explanation made, office objection is overruled. Yes.
Writ of mandamus, my lordship. The petitioner is
AGA is directed to accept notice for the respondents. This is the matter in the preliminary hearing list in the week commencing from.
12.
Yes.
35. Giridhar SV.
Lords, my name has been removed from the revenue records, my lords.
What is the office objection?
We have complied most of the office objection, my lords. Some typed copies are being requested. Lords, I'll furnish the same.
The counsel for the petitioner undertakes to comply with the remaining office objections.
Lords, I've
Yes.
given a representation, my lords. My name is removed from the revenue records, put it back to my vendor's name. I purchased it in 1942. My lords,
accepts
I'm only requesting that they consider my representation in accordance with law.
AG accepts notice for respondent 1 and 2. Relist the matter in the preliminary hearing list on.
Week commencing 12/1.
Yes.
Someday next week, my lords.
No, let us see, let us see.
So number 36.
Please.
Varun Kumar, care.
ಇದು ಆಫೀಸ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಫಸ್ಟ್ ಡೇ ಇಂದ ಒಂದು ಇಲ್ಲ ಅಲ್ಲ ಕರೆಕ್ಟ್ ಬಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಇಂದ ಏನು ಮಾಡಿಲ್ಲ it is noticed that 7 office objections were raised in the year 2023 and despite several opportunities said office objections though partly complied with, still 6 office objections were required to be complied with as per the office order of 31/5/24. Despite several opportunities granted, the office objections have not been complied with. This court, by order dated 24/11/25, had granted 2 weeks' time for compliance of office objection as a last chance. Next, when the matter is called out today, there is no representation on behalf of the petitioner. Clearly, the petitioner is not exercising due diligence in prosecuting the proceedings. Accordingly, petition is dismissed for non-prosecution. Only no representation on behalf of the petitioner. Yes.
37? 37 KBC.
Petitioner, my lords.
So respondent.
Yes.
Question, my lords, whether converted land, my lords, the provisions of the Land Revenue Act would be applicable and mutation entries could be affected. That's the question, my lords. So I,
Seek 6 for adjournment, my lordship, next week or.
let's, it is, last 2 occasions, they were not ready. Same
Because last
submission
week,
is made.
we are ready,
So
the
what
gas
is the-
passed over, the matter could have not reached, the lordship has given date.
What is the answer for that question?
My lords, the settled position, my lords, the case laws, may I place this? my lords? Even where the property is not converted also, that's the court has held, but the provisions of Land Revenue Act would not be applicable.
Page?
My lords, the first, second case law may kindly be seen. I'll do it.
Yes.
Lords, at page 48. This was the case, my lords.
Page?
The page 48 may kindly be seen.
Yes.
This was a case, my lords. The paragraph 3 may kindly be seen, my lords. It is not in dispute that the lands are situated in ward number 9 of Chikbalapur town, and when the property is situated within the town municipal council area, where town municipal council has collected developmental charges from the appellants and granted plan for construction of the compound, and in the planning area, if it has lost the character of agriculture, the deputy commissioner will not get any right to cancel the kata on the ground that the appellants have not obtained an order of conversion. And therefore, we are of the opinion that there is no necessity for the appellants to obtain conversion from agriculture to non-agriculture if the area comes within the town municipal limits and in the background of town municipal council correcting the developmental charges and treated as municipal property. But in my case, my lords, it is a converted land. Now it is coming under the panchayat area. Kata has been transferred in my name, and it's a converted land. Here it was a non-converted land. So even then, once it comes in the city limits, this honorable court has given a finding that.
Now what have you challenged?
My lords, I have challenged the order of the deputy commissioner and the assistant commissioner. My lords,
When was the land converted?
the property, my lords, was converted. Lords, at annexure F may kindly be seen, page 57 on 21st of December 2004. Annexure F.
Yes.
My lords, then my vendor, my lords, he purchased the property after the conversion. I purchased the property way back in 2007. That is the petitioner.
Yes.
And my lords, the The total extent is 1 acre and 38.5 kuntas. The respondents are claiming their right in respect of 13.5 kuntas only, which was sold to my vendor and then purchased by me.
Now, what does the AC do?
My lords, AC acknowledges that it is a converted land, but he says that the mutation, they are the legal heirs. So, and he orders, accepts the endorsement made by the Tahsildar and passes the order. My lords, may kindly peruse the Assistant Commissioner's order at 31.
Now, this, who had gone before the Assistant Commissioner?
Me only, Worship.
My lords,
Who had gone?
the
before
petitioner, my lords.
Petitioner.
Yes, Tahsildar makes an entry. Assistant Commissioner and the Deputy Commissioner
Tahsildar makes an entry.
in the RTC, my lords, bringing the name subsequent to overlooking the fact that it is a converted land. He mutates the entry, brings the name of the respondents 2 and 3.
MR number
My lords.
H12.
Yes, my lords, page 12.
Huh?
Yes.
Page 27.
One.
Page
Yes.
27, H12, then T2, T3, T4,
Yes.
by virtue of which the names of the respondent here is
Respondents 2 and 3 and
affected.
yes, my lords.
In fact, my lordship, we are the grantees.
They are
In fact,
7 years after my purchase.
we have not executed any sale deed, anything, nothing to the petitioner's lordship. In fact, we are the grantees. My father has not executed any sale deed with him. Now they are telling that upon the gift deed, we have purchased, we have acquired the property, and the Chinnamma has got registered the same property in favor of Muniraju. Muniraju took the property from Santosh petitioner.
No, correct. Now we are only on the legal question. So once the land was converted, then the kata will have to be affected by the. Now this comes within which jurisdiction?
The municipal council, my lords.
Municipal
My
council.
lords, and they have already affected the change of kata. My lords, it is at lordship may kindly see at page 61 is the taxpayer receipt. It stands in my name. The
AC and DC reject your.
Yes, my lord. They reject my appeal and then the endorses the the Tahsildar's mutation.
In AC and DC model, they are clearly stated that the title of the flow, how the player purchase property, they are not in anywhere, they are not disclosed. How they, because the grant has been came to us. Upon the grant, how they acquired the property? Because I am the grantee, my father is my grantee. I have acquired the property without my knowledge, without my signature. They have acquired the property. In AC order, they are clearly mentioned that they are nowhere shown that the title of the property, how they got the property. They are telling only gift deed, and they are nowhere they are shown the gift deed, and nowhere they are in AC or DC also clearly mentioned, Marshal.
No, correct. Now,
in that regard.
Now, in whose name the in the panchayat or Zilla Panchayat or which is the authority which has affected kata now?
My lords, in the RTC, my lords, mutation entries of the respondents 2 and 3 have been brought in. My lords, I did not apply for, because my lords, since the property was converted, even when my vendor had purchased it way back in 2004, so I did not make any application for change of mutation entries. It continued in the name of the erstwhile landowner. So the taking advantage of that fact, these respondents 2 and 3, my lords, make an application without even notice to me, my lords. Their names are entered. That I have challenged before the Assistant Commissioner and the Deputy Commissioner.
Correct. Now, before the authority, local authority,
yes,
in whose name kata stands now?
It is in my name, my lords, as per the CMC records.
Where is that?
My lords, I have produced the page 61, may kindly be seen, my lords. This is the e-kata issued under the RDPR. After my purchase, my lords, I have made an application and have been paying the taxes.
This is a Gram Panchayat.
Gram Panchayat. It is under the RDPR.
No, so now if it's converted, then the old revenue entries will go.
Yes.
And then the annexure G, he has got it. If you have any grievance, liberty will be reserved to you to challenge this. Those mutation done after conversion will all have to go. That's the legal position.
And moreover, my lords, the
Just
first,
one,
first,
just one minute. Correct. So now, what? Okay, password, you have a look at it, but I'm saying now, suppose we were to adjudicate, we would only have to say that the order of conversion at annexure F was on 21/12/2004, subsequent to which, if at all there has to be any affecting of mutation, that has to be done by the local authority, not that is a municipal authority or the local body. And under the Land Revenue Act, question of making any entry under 128 does not arise. So that mutation till order of AC and DC will have to be set aside. And now since according to him, he has already effected it, then the grantee will have to be reserved liberty to challenge it in accordance with law.
my lords,
No, so we can now we will not enter into the merits of the case. Now he claims that he has got a kata affected by the local authority. We'll reserve liberty for you to challenge it in accordance with law, while only saying that jurisdiction will subsequent to conversion will be with the local authority, not revenue authority.
I'm a proxy counsel motion because of arguing counsel as today morning,
Yeah,
new
tomorrow.
girl baby has been born to him.
Really?
That's why I seek adjournment.
Relist tomorrow. Now, if you want to have, you have a look at the record. You want to take
tomorrow,
photos,
tomorrow.
tomorrow. No, records you take photo.
Please.
You take whatever photos you want of the record.
Please.
Yes.
I am for the petitioner, please, my lords. This is a granted land. My father was the original grantee. This matter before the formal court is a revisional jurisdiction. And when once in the year 1960, matter was the land in question is a granted land. For subscription, the requirements has been met with by my father.
No, who are the notice has not yet been issued.
Notice has not yet been given.
AGA. Except
It is a revisional power. It is original grantee, please.
Huh?
Original grant.
No, correct. No, let me. Huh? Page. Yes. So that 19/5/86 order already had rejected his claim. Page. Paragraph 57. Annexure. Revision petition 29. Yes. Yes. Now, how many times you are challenging?
Only times, only for change of kata, pavati kata ಮಾಡಬೇಕು ಅಂತ ನಾನು question
It's not
ಕೊಟ್ಟಿದ್ದೀನಿ.
possible because already land has been at,
It has been granted, please, my
For
lords.
other
This is a
persons.
government land
no, I'm saying.
sold by one Bommaka. The sale deeds have been produced by the respondent in collusion with the assistant commissioner and deputy commissioner, have included the properties not included by me in the assistant commissioner. Several other properties in the year 1941, 42 and 52, 53 sold by one Bommaka. It's a government land.
Forget it. Now, 3 times already it was rejected. Page 52, third paragraph. Already it was rejected on 27/3/2007. Endorsement is issued that the lands have been granted to other persons and kata in their names. Hence, application for change of kata is not admissible. That what
That's
happened?
illegal order. It's a government land.
No, that you can't challenge now.
Because before revisional court,
No,
this
no.
is the revisional court before which authority, there has been several properties not included, not in the name of my grandfather, has been included only to help the respondents.
Maybe.
Illegal order, land grabbing order.
You can't come again and again on the same. Even quasi judicial authority res judicata operates.
Res
2000
judicata, no, please,
yes,
my lords,
yes,
my,
that is
I
a
have
legal
got a good case on merits.
No, we can't enter into that. Only on the point on 27/3/2007, already Tahsildar has issued endorsement.
Stating that since the matter is only for pavati kata, when once it has been a granted land, it's a government land. Question of sale deed in the year 1941 and 52 does not arise.
No,
And it is a collusive order passed by the deputy commissioner in a revisional petition.
No,
A challenge before
your
the
writ
Sample
petition,
Court.
your writ petition 12248 of 83
Yes.
was also rejected.
It was rejected only for payment. Payment does not arise.
No,
The
no,
government has not
we
recalled
can't-
the sanction granted to the petitioner's father.
We can't reopen all that.
We cannot revoke, but it's illegal order. Challenge to before the Sample Court.
You can't do that. Once the quasi judicial authority have rejected it, once the High Court has rejected.
High Court rejected only for payment of the money.
You can't now come on merits. You can't come
Not on only on the 130 to 136 revision petition before the Sample Court, challenging the veracity of the orders passed by the deputy commissioner and
Your
assistant
RA,
commissioner.
your RA 136 of 2007-8 was rejected.
Yes, rejected only for, I have no jurisdiction. The Lordship may kindly see annexure A. Annexure H, please, my lords. This is order passed by the annexure. Since he has no jurisdiction to try the matter when once it has been granted by the deputy commissioner, he cannot go into the matter that for grant of kata in favor of the petitioners
The Assistant Commissioner
Has no
observed-
jurisdiction.
has
He has
observed
passed it. Respondent submitted, the petitioner had filed an application for
Page.
change of kata.
page.
Page number 51, please, my lords, in the revision petition.
No, where is that order? You take the order of RA 136 of
130, Adesha.
2007.
Mail with, page number 48. ಮನವಿದಾರರು ಬಹಳ ಹಿಂದೆ ಪ್ರತಿವಾದಿ 2ರಿಂದ 7 ಹೆಸರಲ್ಲಿ ಆಗಿರುವ ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು ಪ್ರಶ್ನಿಸಿರುತ್ತಾರೆ. ಈ ಪ್ರಾಧಿಕಾರವು ಇನಾಮ್ ರದ್ದತಿ ಆದೇಶದ ವಿರುದ್ಧ ಮೇಲ್ವಿದಾರರು ಪಡಿಸಿದ ಮನವಿಯನ್ನು ಆದೇಶ ಸಂಖ್ಯೆ 29/81/82 ಡೇಟೆಡ್ 9/5/1986 ಇನಾಮ್ ಜಮೀನುಗಳ ಆದೇಶದ ಮಾಡಲು ಈ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿ ಇಲ್ಲುವುದರಿಂದ without jurisdiction he has to dismiss the petition. Doesn't mean that on merits he has dismissed. Has been challenged too. Without merit, without jurisdiction, this Assistant Commissioner has once again remitted the matter back to the Commissioner, Deputy Commissioner. Deputy Commissioner has in fact favored the respondents.
Where have you challenged the order of the Assistant Commissioner of 27/3/2007? The
Which
order
order
of the-
has not been challenged, please, my lords.
There ends the matter.
Order copy ಕೊಡ್ತೀನಿ ನಾನು because I have not, I could not have.
Under 136(2).
Yes.
Assistant Commissioner passed an order on 27.
136, only Deputy Commissioner can pass the orders. He has no jurisdiction.
Under 136(2).
Yes.
Ah.
Only Deputy Commissioner has got the revisional powers. And the revisional powers, revisional order passed by the Deputy Commissioner has been challenged to before this authority.
Under 136(2).
2.
On 27/3/2007, Assistant Commissioners passed an order. Where have you challenged that order till date?
That order copy I don't have, please, my lord. This is only
That you
one
can't-
order without jurisdiction. He has passed an order. He has rejected. I have no jurisdiction. That kind of order is not a speaking order. For the purpose has been challenged to before the authority, Deputy Commissioner 136/2, revisional power.
No, you can't challenge it now.
I can, please, my lords, I will prove this honorable court that there is only collusive illegal order passed only to favor the respondents. The Deputy Commissioner has gone to favor the respondents by saying that in the year 1941-42 itself, the respondent number 2 to 7.
You withdraw it other than imposed cost. It's up to you. I'll give you a date. If you don't withdraw, I'm going to impose cost. The petitioner in the present petition has challenged, has sought for issuance of writ of mandamus to pass orders in revision petition 29/2016-14. In terms of Annexure K, the Deputy Commissioner had by a detailed order dismissed the revision petition. While upholding the order passed by the Assistant Commissioner in RA 136/2007-8 dated 22/6/2016. No, you have sought for setting aside of the order of the DC.
AC. One in divisional powers exercisable by this honorable court only to set aside the orders passed by the Deputy Commissioner, who has included other properties not included in the Assistant Commissioner's court. Only to favor the respondents, illegal order, land grabbing.
The Deputy Commissioner in RA 136/2007-8 had dismissed the appeal filed under 136 subclause 2 of the Act by a detailed order. It must be noticed that the Deputy Commissioner, while disposing of revision petition 29 of 2016-17, has made certain observations regarding earlier rounds of approach before the revenue authorities. Full stop. Observations made at page 57. On careful perusal of the contentions put forth by the parties and records placed on file, it is found that so and so in the till next page, order passed by the Assistant Commissioner and Tahsildar was upheld. Full stop. It is clear that there were previous approaches by the petitioner before the revenue authority, and the revenue authorities had issued endorsement as regards application for transfer of Kata, stating that the land in question had been granted to other persons and Kata was in their names. And accordingly, application for Kata could not be reconsidered.
Kata in my name, please, my lords. Forum number 8 also.
It is noticed that the endorsements by
Forum number
the
8 is standing in my father's name.
endorsements of the Tahsildar of 27/3/2007 and 29/6/2007 were challenged in RA 136 of 2007-8. And was rejected by holding that the Special Deputy Commissioner for Abolition of Inams had already granted lands The Deputy Commissioner has also noticed that the petitioner H. Govindraju was the appellant, who was the revision petitioner before the Deputy Commissioner, as well as was the appellant before the Assistant Commissioner. Had filed an appeal challenging Kata in appeal 29 of 81-82, which was dismissed by order dated 19/5/1986, and the writ petition filed in WP 12248 of 1983 challenging such order of the Assistant Commissioner and Tahsildar was also rejected while upholding such orders of the revenue authorities. Full stop. It is submitted. It is noticed that petitioners once again have approached the Deputy Commissioner So it is noticed that the grant in favor of the father of the petitioners, that is Hanumaya, is it?
Hanumaya is my father.
Hanumaya, was subject to payment of premium, which condition was not complied. The writ petition 12248 of 83 filed by the petitioner's father
Petitioner for.
also has been rejected. Upholding order passed in favor of other private parties by the Special Deputy Commissioner for Abolition of Inams.
My humble submission at this stage, please, my lords. Since it's a government land, without authority, in the year 1941, 52 itself, 41, 42, and 52, 53, the sale deeds have been entered without permission. It's illegal sale deeds.
Let us,
Sham documents, please, my lord,
Let
relied
us-
by the respondents.
we find that in light of dismissal of the writ petition WP 12248 of 1983, and the earlier rejection of application for change of kata at the instance of Hanumaya having attained finality, the fresh round of raising the issue under identical circumstance cannot be entertained and the petition is rejected. Yes.
It is a government land, please, my lords. Without authority, permission, it has been sold.
Now you have not paid premium, there ends your right. Yes.
The Act does not provide that in case premium is not paid in time.
The writ petition was dismissed. What we can do? Yes.
The matter was, Lordship said the matter could be disposed of, in fact, on the application filed for early hearing. Matter, according to me, is fully covered by the full bench judgment of this honorable court in the Chikira Timaya's case, and having regard to the latest judgment of this honorable court in 55534 of 2013, which is passed subsequent to the amendment made to section 220 of the Karnataka Land Revenue Act. I think that judgment fully covers all the points involved. The tribunal, I am aggrieved by the order of the tribunal only insofar as it relates to the direction issued to take possession of the land from me and to change the kata which has been standing in my name all these years, right from 1956. The entries I have produced, Jamabandi extract, ella hajar madidu. I have, before I start, even 2023-24 in the article, I have given a copy to my learned friend. I have filed my synopsis on 31/8/2023. Since the documents are voluminous and the file is bulky, I have prepared the synopsis and points for consideration. I think if I take your lordship through that, it will be very clear. It is a privileged Jahagir Bane land malad in Kurd district. The ancestors of the petitioners, they were in possession of the same. Subsequently, the petitioner, even now he has been in possession of the same. The tribunal says that state should take possession from me and khata in my name should be changed to the name of the government. Several documents have been produced to show that the petitioner has grown even coffee and pepper in the land in question. And 2012, when he was trying to clean the area and clear off certain bushes, etc., case was registered against him and a fine was imposed.
The state has filed your statement.
Yeah, the state has filed the statement.
What is your stand?
Lord, our stand is it comes under certain Karnataka state, Karnataka certain Inam Abolition Act. Accordingly, they are not in possession of the said land. That is what the tribunal has stated in their order. If your lordship may kindly take up the order of the tribunal, Miller. Annexure.
A.
Annexure A, Miller, page 20, 18 it starts. Annexure A, page 18. Your lordship may kindly take up page 20, Miller. Page 20 of the order.
Yes.
Page 20, Milord, in that from below, second para, Milord. Unyaya Mandaliya. May I read, Milord? Unyaya Mandaliya ಸ್ಥಳ ನೈಜ ಸ್ಥಿತಿ ಗತಿಯನ್ನು ತಿಳಿಯಲು 1964 ಭೂ ಸುಧಾರಣೆ ಕಾನೂನು 17ರಂತೆ ದಿನಾಂಕ 4/5/2012 ಕೆ ನೆಡುಗೋಡಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 9/1 ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ಸರ್ವೆ ಕಾರ್ಯ ನಡೆಸಿ ಅನುಭವವನ್ನು ವಿಸ್ತೀರ್ಣದ ನಕಾಶೆಯನ್ನು ತಯಾರಿಸಲಾಯಿತು. ಶ್ರೀ ಕೆ.ಬಿ. ಉತ್ತಪ್ಪನವರು ಸರ್ವೆ ನಂಬರ್ 9/1 ಪೈಕಿ 9 ಎಕರೆ 60 ಸೆಂಟ್ ಕ್ಷೇತ್ರದಲ್ಲಿ ಹಳೆ ಏಲಕ್ಕಿ ಬೇಸಾಯವಿದ್ದು 10 ಸೆಂಟ್ ಜಾಗದಲ್ಲಿ ಒಂದು ವಾಸದ ಹಂಚಿನ ಮನೆಯಿದ್ದು ಒಟ್ಟು 9 ಎಕರೆ ಅನುಭವ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ಉಳಿದ ಜಾಗವು ಸಂಪೂರ್ಣವಾಗಿ ಖಾಲಿ ಇರುವುದಾಗಿ ಹಾಗೂ ಟೆಂಪಲ್ ಕಮಿಟಿಯವರು ಸದರಿ ಜಾಗದಲ್ಲಿ ಸ್ವಂತ ಯಾವುದೇ ಕೃಷಿ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ. ದಟ್ ಮೇ ಬಿ ನೋಟೆಡ್. ನಾವು ಬೆಳೆದಂತೆ ಫಸಲಿನಲ್ಲಿ ಗೇಣಿ ರೂಪದಲ್ಲಿ ದೇವಸ್ಥಾನಕ್ಕೆ ವತಿ ನೀಡಿರುತ್ತಿರುವುದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
Temple Fund Committee is respondent for 4 million. I am sorry.
ದಿನಾಂಕ 4/5/2012 ಸ್ಥಳ ಪರಿಶೀಲನೆ ವೇಳೆಯಲ್ಲಿ ಕಂಡು ಬಂದಿರುವಂತೆ ಹಾಗೂ ಶ್ರೀ ಕೆ.ಬಿ. ಉತ್ತಪ್ಪನವರು ಹೇಳಿಕೆಯಂತೆ ಸದರಿಯವರು ಅನುಭವದಲ್ಲಿರುವ 9 ಎಕರೆ ಜಮೀನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಜಮೀನಲ್ಲಿ ಯಾವುದೇ ಬೆಳೆ ಬೆಳೆದು ಖಾಲಿ ಇರುವ ಖಾತ್ರಿಯಾಗಿರುತ್ತದೆ. ಕೆ ನಡುಗುಣಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 9/1 39.78 ಪ್ರಿವಿಲೇಜ್ ಜಾಂಗೀರ್ ಜಮೀನು ಇನಾಮ್ ರದ್ದಾಯಿತಿ ಕಾಯ್ದೆ 1977 ಕಲಂ 4ರಂತೆ ಸಂಪೂರ್ಣವಾಗಿ ಸರ್ಕಾರದ ವಶಕ್ಕೆ ಸೇರಿಸಲುಂಟೆ ದಿನಾಂಕ 1/3/1974 ಮುಂಚಿತವಾಗಿ ಸತತವಾಗಿ ಕೆ.ಬಿ. ಉತ್ತಪ್ಪನವರು ಜಾಗದಲ್ಲಿ ಕೃಷಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ರಾಜ್ಯ ಸರ್ಕಾರ ನಿಹಿತವಾಗಿ ಜಮೀನು ವಿಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಹಲವು ಇನಾಮ್ ಜಮೀನುಗಳ ರದ್ದಾಯಿತಿ ಕಾಯ್ದೆ 1974 ಕಾನೂನು 26ರಂತೆ ರಾಜ್ಯ ಸರ್ಕಾರದಲ್ಲಿ ನೇತಿವಾಗಿ ಮತ್ತು ಈ ಅಧಿನಿಯಮದ ಅಧಿಭೋಗ್ಯದಾರನಾಗಿ ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ಹಕ್ಕು ಯಾವುದೇ ವ್ಯಕ್ತಿ ಸಂಬಂಧದಲ್ಲಿ ಆ ನಿಯಮನಗಳನ್ನು ಭೂ ಸುಧಾರಣಾ ಅಧಿನಿಯಮ 1964 77ನೇ ಪ್ರಕರಣಗಳ ಬಂಧಗಳ ಅನುಸಾರವಾಗಿ ವಿಲೆ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಕೊಡಗು ಟೆಂಪಲ್ ಕಮಿಟಿಯವರು ಸದರಿ ಜಾಗದಲ್ಲಿ 10 ವರ್ಷಗಳ ಮಿಗಿಲಾಗಿ ಕೃಷಿಯನ್ನು ಮಾಡದೇ ಇರುವುದಿರದಲ್ಲೂ ಹಾಗೂ ಶ್ರೀ ಕೆ.ಬಿ. ಉತ್ತಪ್ಪನವರು 1/3/1974 ಮುಂಚಿತ ಕೃಷಿ ಮಾಡಿಕೊಂಡು ತನ್ನ ಸ್ವಾಧೀನತೆ ಕಾಯ್ದುಕೊಂಡು ಬಂದಿರುತ್ತದೆ. Lord, these are the points, and further next para, my lord, further it says
Continue at 2:30.
Please.
Your lordship, with kind permission, serial number 49.1, your lordship, permit me to withdraw the petition. Your lordship, there we are not observed that previously the government issued one.
At 2:30 I'll take it up.
Submission.
Huh?
One matter, my lord, for tomorrow.
Special.
ಕೋರ್ಟ್ ಹತ್ರ ಬಾ, ಏಳಕ್ಕೆ ಬೇಗ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹಂಗೆ ಅವತ್ತೈದು ಕಾಲ ಸಾಹೇಬ್ ಏನಿದೆ ಸ್ಪೆಷಲ್ ಸಂಜೆ
ಏನು ಮಾಡ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿ ನಾಳೆ ಮಾತಾಡೋಗ್ಬಿಟ್ಟೆ ಬೆಳಗ್ಗೆ ಹಿಂಗೈತೆ ಇದು ಇನ್ನೊಂದೈತೆ ನುಂಗ್ಬಿಟ್ರೆ ಅಷ್ಟೇ ಇದು ಅಷ್ಟೇ ಇಲ್ಲೇ ಮಾಡ್ಕೊಬೇಕಾಯ್ತು ಖಂಡಿ ಸಿಕ್ತು ಆಫ್ ಮಾಡಿದೀವಿ ಅದನ್ನು ಹೌದು ಇಲ್ಲಿ ಆಫ್ ಕೂಡ ಸತೀಶ್ ಫ್ಯಾನು ಸಿಕ್ಕಾಪಟ್ಟೆ ಇದೆ ತಣ್ಣಿ again after.
My make on submission.
Yes.
My lords, this is special petition, my lords. Petitioner is MLC, my lords. Day after tomorrow, matter is listed before the trial court. Kindly have it tomorrow, my lords. Offense is 505 clause 2.
You have to wait on Thursday. No, charge sheet is filed, no.
Please, ma'am. Charge sheet is already for framing of charges.
I'll have it on Thursday, but you take it from me, I'm very conservative. So only after, we'll see on Thursday what happens.
Please, ma'am.
That is 39. Krishnamurthy Asika.
The records are required in this.
So records have secured records.
Huh?
Have secured records.
How much time you will take?
To show that I have been in possession and the enjoyment of the property, several documents have been produced. I have filed my synopsis with all details. I have given reference numbers of the page numbers amongst all those documents. That is what I was thinking. I will definitely take some time so that I was feeling guilty. There are several persons waiting for preliminary hearing. If your lordship could treat it as matter and have it next week at 2:30, I think it could be disposed of because the matter is fully covered by.
Let us see, but not on this part of the vacation. We'll have it in the first week immediately after vacation.
It may be treated as part track. The preliminary hearing ಎಲ್ಲ ಬಂದು ಮುಗಿಸ್ಬಿಟ್ರೆ because my client is 73 years old.
Look, I appreciate, but part heard I cannot. There's some difficulty. I relist the matter in the week commencing from 5th of January.
Please.
5th of January.
5th first week ಆಗುತ್ತೆ. Second ಯಾವ್ದಾರು
12th.
Please 12th of January preliminary list ಅಲ್ಲಿ ಅಂತ ಹೇಳಿ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
Same stage.
ಸೇಮ್ ಸ್ಟೇಜ್. Sorry my lord.
No, that's okay.
40. So 30.
Matter on petitioner.
For respondent 15 in this case.
The agricultural land being diverted to non-agricultural purpose without there being any conversion order, layout plan, millets. The joint survey conducted by the authority clearly disclosed that the land laws are completely violated, millets, in this matter.
Yes.
Lord, there is I appear for respondent. I'm also one of the contesting respondent. Now, Lord, the report says that I have put up construction also. Now, Lord, I have purchased only 1 gunta, 1.25 gunta na ಕೊಂಡ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್. ಕೊಂಡ್ಕೊಂಡು ನನಗೆ ಪ್ಲಾನ್ ಅಪ್ರೂವ್ ಮಾಡಿದ್ದಾರೆ ಇಂಡಲವಾಡಿ ಗ್ರಾಮ ಪಂಚಾಯತಿನವರು. Based on their approval, my lord, I have put up construction borrowing home loan, my lord. Now, my lord, the allegation is that the agricultural land have been diverted without taking the conversion order. That is the gist of the allegation. Now, my lord, this honorable court, my lord, this honorable court have held in several cases that there is a provision under 96(4) if there is any such things. Based on that, penalty can be levied and it can be regularized. To that effect, may I just place reliance on this judgment, my lord.
Millets, in this matter, there are 10 police officers.
Lord, may
We
I just
have
take your lordships to
colluded,
the paragraph number 6. Paragraph number 6 of the judgment, my lord. However, the respondent number 2 ought to have noticed, say, section 96(4), which provides for compounding the diversion of agricultural land for non-agricultural purpose on payment of prescribed amount, which may be different for different area or for different contravention or for different purposes. Now that the petitioner has already put up construction, demolishing the same would not serve any useful purpose, but would be a national waste. In view of the statement
That we leave it to the government. If they want to do it, let them take a call.
My lord, I made a similar representation before this honorable court, my lord, before the authorities. Based on this judgment, I made a representation. Now, my lord, and since they have not considered, I have filed a writ petition which is kept below in this case. Now, my lord, this honorable court directed if there is any provision to use this provision, make use of it and give him the appropriate relief. That was the judgment passed by this honorable court. But unfortunately, my lord, Day before yesterday, they have given an endorsement that cannot be considered. Day before yesterday, in a day or two, petitioner respondent number 15 is also before this court. Now, my lord, if such a, my lord, if I'm permitted to use this, my lord, I'll be, because I will borrowed home loan and put up construction. I'm a purchaser, I'm not the landlord.
No, correct. So now what can be done?
96.
No, now endorsement is given, there ends the matter.
Now, my lord, day before yesterday, and my lord, pendency of this, my lord, even if I challenge that, this pendency may come in the way, my lord, therefore I'm pleading before this honorable court, reserving liberty that to make a fresh application under 96(4) of the act, I'm ready to pay the compounding fees
No,
also.
correct. Now they've rejected. You'll have to challenge that.
My lord, rejects, we have not asked in this provision, my lord. We sought, my lord, why we made a different representation. Our representation was that, my lord, the land what is alleged is just abutting Kirangadur village, my lord. Kirigandur village, just abutting the Kirigandur village. We were under the impression that it is a Gram Thana land. So therefore, conversion is not required or no impression. Now hogidvi. That representation was reading like that only. Now, my lord, if they come to conclusion that the 95 applies, then 96(4) benefit can be given, my lord. We were under that impression, my lord, because it is not more than 100 meter away from the village.
Correct. Now they've rejected it. So what we can do now?
Now, my lord,
You have to challenge that.
my lord, I'll challenge that one, my lord. In the meantime, my lord, if the matter can be disposed of, reserving, if there is any such provision under, my lord, using this, if anybody comes for compounding, let it be considered. If any individual comes for compounding, my lord, I'm not asking for all respondents, my lord. Let there be an order that if any respondent want to compound by paying the compounding fees, it will be considered.
If they've rejected against one, then unless that is decided, how we can, what is the purpose of?
Your lordship may have it day after, my lord. Your lordship may have it next week, my lord. I'll challenge that also, and so that I can make an application for clubbing of both the matters.
May I make one request, for the respondent number 6, that if my learned friend's argument is accepted, in every agriculture land, layout can be found, sites can be sold, and afterwards they can compound the offence. That is not the purport of section 95 or section 17 of the Karnataka Government Central Planning Act. This cannot be allowed to continue forever. We have to put full stop at one point of time. Using the agriculture land for formation of residential layout and selling the sites to various persons, all of them are in soap now because of the act of the respondent number 10. We have also initiated proceedings against respondent number 10, who has formed the layout and sold it to the private respondent. But I am setting my counter. I am producing the copy of the notice issued to respondent number 10 also.
My lords, one submission, my lords, in this matter.
But I would rather, I cannot have any say for the argument of my learned friend Vivekananda. But, my lord, in this case, my lord, it is the authorities who have given the license for me to put up construction.
So we'll hear the matter. Let us. The statement of, let us see. So we'll have to hear the matter on merits.
My lord, what house construction, what I have done is not yet plastered, my lord. Because of the non-plastering, my lord, I may have to lose the entire building, my lord, because it is more than 2 years. It is left like that only.
No, correct. That we'll see whether it has to be demolished or not.
It's a different aspect, and my lord, license is granted by them.
My lords,
The
one
objections
submission.
filed by R6 is taken on record. Now let it be heard, get ready on the main, that's all.
A date will
We'll list the matter in the week commencing from.
12th of January.
Yes.
41.
Much of
Right.
Much of
Yes. Interim order in operation, here it will be extended to the next date. Yes.
41.
Respond number 6.
Yes.
Kindly pass on. Kindly pass on.
Don't reach today. Pass over. Otherwise, I take a chance some other day.
Challenging the order of the council on record is quotal number 7.
So
sorry, 6.
Correct. So we'll take it some other day.
Urgencies. There is some urgency.
What is urgency?
Petitioner is challenging the order of the third respondent. My lord, annexure L.
Land reforms, is it?
Land reforms, podi durasti idra baggene. The land bearing page number 76, my lord. Page number 76.
Yes.
ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರ ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ಅವರ ಪದನಿಮಿತ್ತ ಭೂ ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕರ ನ್ಯಾಯಾಲಯ. ಬೇಡ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಇಸ್ ಮೆಲಾಡ್. ದಿ ಮೇಲ್ಮನವಿದಾರರು ಅವರಿಗೆ ವ್ಯವಸ್ಥಾಪನಾ ಪತ್ರದಂತೆ ಬಂದ 0.4 ಎಕರೆ ಸ್ಥಳವು ಸರ್ಕಾರಿ ಜಮೀನಿಗೆ ತಾಗಿಕೊಂಡು ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ FMB ನಕ್ಷೆ ಮತ್ತು ಮೇಲ್ಮನವಿದಾರ ಹಾಜರುಪಡಿಸಿರುವ 11E ನಕ್ಷೆಯಂತೆ.
So now state has filed their objections.
No, madam.
Then let
Last
them file,
occasion
then
there
we'll see. Now the order is of podi and plotting. Let the state take their stand, then we'll decide the matter. Without the state's response, how we can decide? AGA.
Lords, if I may submit, Lords, I appear for respond number 6. Lords, this is not an issue, Lords, that pertains to podi. Lords, there are 2 suits filed. Lords, I file a suit for declaration and permanent injunction, Lords, which is decreed in my favor. Lords, after I obtain a decree, they file a suit for declaration permanent injunction. It is dismissed. Now, Lords, to revive the podi proceedings, Lords, they file this writ. Lords, the title is already established. I am in possession, Lords. I am the owner of the land bearing survey number 74/1. Now, my lords, the ADLR, the JDLR, both of them, my lords, pass orders wherein, my lords, they say 2 suits are pending, and until the suit is decided, I cannot interfere. Now the suits are decided. My lords, the suits are decided in my favor that I am the owner. Now, my lords, notwithstanding this, they file a writ saying the podi is not done correctly and notice is not issued to me. It is not the issue of podi at all. My lords, the only issue is with regard to who the owner is.
Let the stand. Let the state take the stand, we'll hear it.
My lord, on the last occasion, your lordships had sought for a clarification on the allegation made by the petitioner that no notice was issued to the petitioner insofar as, and an 11E sketch endorsement was issued stating that the signature acknowledgement of the 11E sketch. The only clarification that I would like to provide now, my lord, is this podi proceedings that the petitioner is referring to is only insofar as survey number 74/8 is concerned. There, it was done on the application made by the petitioner. The 11E sketch was furnished to the petitioner, which is acknowledged. My lord, that is the only clarification your lordships had sought. I'll file a memo to that effect, my lord. So the petitioner is confusing the issues while referencing other lands. The petitioner is saying 11E sketch has been done without notice, whereas even as per the contentions of the petitioner, it is pertaining to 74/8.
Give it. Plotting was done, my lord, without my back. There is no notice for me. It is my contention.
Lords, the whole case, Lords, is established, is trying to establish,
The
Lords,
court commissioner
that the plotting is not done correctly. Lords, this is not an issue of plotting at all. The issue, Lords, is with regard to who the owner is. I have already, Lords, filed a suit, established my right. I have a decree in my favor. Now, Lords, a writ is filed saying podi proceedings are not done correctly.
I have challenged the podi proceedings in this.
So, your lordship may see the order of the DDLR, Lords. He says, since 2 suits are pending, I cannot get into this issue. And he says, until the suits are decided, no order will be passed. Against which, Lords, they challenge and say, Lords, the podi proceeding is not done correctly.
No, you give me your memo.
My lord, the petitioner has challenged annexure L, my lord, which is the order of the JDLR. In that, my lord, may kindly turn to page 77 of the petition, my lord, annexure L.
Yes.
This is an this was pertaining to land bearing 74/1, and in that specifically 74/12, my lord. ಮಾಡಿದ ಪ್ಲಾಟಿಂಗ್ ಪ್ರಶ್ನಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು so and so ರಂತೆ ನೋಂದಾಯಿಸಲಾಗಿರುತ್ತದೆ. After investigation, my lord, at page inquiry, at page 77, my lord, ಕಾರಣಗಳು.
Yes.
ಮೇಲ್ಮನವಿದಾರರು ಅವರಿಗೆ ವ್ಯವಸ್ಥಾ ಪತ್ರದಂತೆ ಬಂದ 4 ಎಕರೆ ಗುಂಟೆ ಸ್ಥಳವು ಸರ್ಕಾರಿ ಜಮೀನಿಗೆ ತಾಕಿಕೊಂಡು ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ FMB ನಕ್ಷೆ ಮತ್ತು ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರುಪಡಿಸಿದ 11E ನಕ್ಷೆ ಅಂತೆ. They have themselves produced the 11E sketch. ಮೇಲ್ಮನವಿದಾರರ ಮತ್ತು ಸರ್ಕಾರಿ ಸ್ಥಳದ ಮಧ್ಯೆ 1ನೇ ಪ್ರತಿವಾದಿಯವರ ಜಮೀನಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಸದರಿ 11E ನಕ್ಷೆಯನ್ನು ಮೇಲ್ಮನವಿದಾರರು ತಪ್ಪಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನಿನ ಬಾಬ್ತು ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಮೂಲ ದಾವೆ ನಂಬರ್ 512 of 2017 ರ ಪ್ರಕರಣವು ಇದೇ ಪಕ್ಷಗಾರರೊಳಗೆ ವಿಚಾರಣೆಗೆ ಬಾಕಿ ಇದ್ದು, ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಿಂದ ನಿಯುಕ್ತಗೊಂಡ ಸಲ್ಲಿಸಿದ ವರದಿ ಮತ್ತು ನಕ್ಷೆಯನ್ನು ಮೇಲ್ಮನವಿದಾರರು ಆಕ್ಷೇಪಿಸಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ. Now the petitioner is contending, my lord, 11E sketch has been prepared without, there is no 11E sketch prepared in so far as other numbers are concerned. This was on the basis of the application made. The petitioner himself had produced the 11E sketch. There is mixing up of issues, my lord. 74/1 has been plotted into several portions.
Where is that 11E sketch?
That, my lord, it's part of my memo. That would be the third document, my lord, at page 6.
Yes.
Lord, I have taken specific contention in annexure L, my lord. And the page number 76, kindly may observe, my lord. ಈ ಮಧ್ಯೆ ಪೇಜ್ ನಂಬರ್ 76, ಈ ಮಧ್ಯೆ ಪ್ರತಿವಾದಿಯವರ ಶ್ರೀಮತಿ ಸುಗಂಧಿ ಅವರು ಈ ಜಮೀನಿನ ಪ್ಲಾಟಿಂಗ್ ಮಾಡೋ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ತಿಳುವಳಿಕೆ ನೀಡದೆ ತನ್ನ ಮನೆಯಡಿ ಸ್ಥಳವನ್ನು ಸೇರಿಸಿ ಸರ್ವೆ ನಂಬರ್ 73/12 ಎಂದು ಪ್ಲಾಟಿಂಗ್ ಮಾಡಿಸಿರುತ್ತಾರೆ. ಸದ್ರಿ ಇಸೆಯನ್ನು ರದ್ದುಪಡಿಸಬೇಕಾಗಿ ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಮೇಲ್ಮನವಿ ಕೋರುತ್ತಾರೆ. Lord, there is no specific notice served on me, my lord.
So the 11E sketch was served on him.
Please, my lord, that document number no, my lord, the 11E sketch was produced by the petitioner. This 11E sketch pertains to survey number 74/8. My lord, in this matter, we'll have to explain it with detailed objections, my lord. I'll have to submit that because 74 has been supported. There's some confusion insofar as the presentation of the petitioner is concerned.
Correct, but now what is your apprehension on the basis of this plotting? What is going to happen?
Lords, nothing. Your lordship, my lords, may see this paragraph that your lordship just read, page number 77. Lords, they specifically say that the suit is pending, and only after the suit is decided can I get into the issue of whether podi is done correctly or not. Now, my lords, the suit is decided, a decree is done, my lords, in my favor, and the title is already decided in my favor, my lords. Nonetheless, they filed this writ. The issue, my lords, with greatest respect, my lords, is not with regard to the podi. The writ is styled, my lords, as though it is to do with the podi.
I have challenged the order of the.
Lords, everything boils down, my lords, to what happens in the suit. 2 suits are filed, my lords. Both of them are in my favor.
What do you say regarding the suit?
And they do not produce the decree copy, my lords, along with the writ.
I'm not challenging the original suit.
No, you're a party to the suit.
He's the one who's filed it.
But I'm challenging the proceedings of the.
So you produce
ADLR.
Correct. Now you produce the suit. Let us have a look at the decree. Declaration is also.
Lords, they file a suit for declaration permanent injunction. It is dismissed.
You produce.
My suit for declaration, lords, is decreed.
You produce
on the basis of that, lords, these orders are passed.
So you produce the orders. Let's have.
I'll produce it, lords, but in the writ, they do not take note of this fact and say, lords, this is to do with podi.
Correct. So let us see some grievance he has. You produce the judgment.
There is no grievance, lords. The grievance is styled to revive, lords, the podi proceedings and say they are the title owners.
Let us see. Both parties to.
Lord, kindly pass it over, my lord.
Today it's not going to.
Please, my lord.
It's not going to. I have a part heard bail matter at 3:30. I'm not going to take any matter after 3:30. Before 3:30, it's not going to reach.
Tomorrow, my lord, please.
Both parties.
Tomorrow.
No, you give do you have a copy of the judgment? You have to produce it, isn't it? So you get and produce it.
There are two
copy
issues,
of the judgments in OS.
OS number 512 of 2017, which they have filed.
512 of 2017.
Which is dismissed, my lords, on 19/10/2024.
And
the suit that I filed, my lords,
OS
number 1199 of 2019, which is decreed.
1199 of 2019
19, which is decreed in my favor.
to be produced. Relist the matter.
My lord, since till then there is no interim order may be granted. I have not, coercive action does not
We have
taken by
not-
the respondent, my lord.
What
That
is
is my interim prayer.
You produce the judgment copy, I'll have it
I'll
next.
produce, my lord. Till then-
Relist the matter next
Till
week.
then, my lord.
Next
Till-
week.
Please, interim order may be considered, my lord.
Without seeing the judgment and decree, I'm not going to pass it.
16th, 42.
Gratefully.
16. My only grievance is, my lord, forum number 7.
R5? R5.
R5 is the land tribunal, my lord.
42.
42.
42, please, my lord. Last time orally instructed the government advocate to look into the issue. I mean, the proceedings are pending before the land tribunal, Kollegala, since long time. My father expired. My father had filed the, I mean, petitioner's husband.
Proceedings are not yet concluded.
Not yet.
My instructions, my lord, that earlier tribunal, what was constituted, subsequent to the new government, they have removed that old tribunal. And as per the new notification, they have, the rule says to the people who are the new committee members, the list has been sent. In that, it has to be scrutinized before the superintendent of police to verify if there is any legal case against them. In that, what has happened, 2 of the members, they have not cleared. Now again, it is sent to the government now to be, a new list has to be sent. So that is where it is held up now.
So one day, last week, before vacation, 2 weeks.
Lord, and now it is pending before the government. It will take more than 3 months, my lord. So it can be taken
Lord,
up sometime in
my-
January, after court reopens, 3rd week in the January, my lord. In the meantime, I'll see to it some progress is done.
No, unless that is done, we can't do anything.
We can't do it.
On submission to be, my lord. In the meanwhile, certain third parties are making sale deeds and obtaining kata and other things in their favor. Kindly see endorsement issued by the Tahsildar, page 30, my lord, page 30.
No, just only. Now, who is the persons claiming under the land? You are the tenant.
I am the tenant. My father was the tenant.
Now, for the time being, you implead the landlord and you seek for a direction.
Landlord is not coming, my lord. Landlord is not troubling me.
No. Persons who are now creating third party.
That I can make, my lord. One for K Nagaraj. He has sold 4 cents land in 58/1 and kata has been made.
So you seek for appropriate relief, restraining the creation of third party rights, make him a additional respondent, we will consider.
I will.
Lord, may I just produce the letter?
Realistic. AGA submits the constitution of the tribunal. Constitution of the tribunal is in process.
This is the letter issued by the Tahsildar with regard to the same, my lord. If your lordship may kindly last param.
Taking note of the same, relist the matter in the 2nd week of January.
Please.
In the interregnum, as petitioner submits that third party rights are being created by certain persons, it's open for the petitioner to seek for appropriate relief in the present proceedings. Yes.
43, Badrinath.
Date may be given, my lord, one date. Any date in this.
Put a date.
19th.
Great.
43, Badrinath R.
I pay for petition. Regarding death of the respondent number 5, they had to produce the death certificate. Details has been not furnished. It's only a small point where the land tribunal order is. I can look into annexure M.
Correct, but what do you do of R5 now? We are going to pass an order on merits. R5 proceedings must be, we have to bring the LRs.
Details has been not furnished. Only the death certificate had been furnished. Last occasion where the Sanko directed to furnish the details also.
Counsel for R5.
517.
is to indicate details of the legal representatives of the fifth respondent who stated to be dead. Counsel who was appearing for R5 earlier is to state details of legal representatives of R5 as it is stated that R5 is dead. Our Kodala, what you must also make some effort.
And
Relist. Yes.
Records have been secured.
Huh?
Secured the records.
Let us. You can see if you want to take some photographs.
I'd seen the records.
No, if you want to take some photographs, scan it and keep it. If it's going to help you later, we'll see. Yes.
44, symbol of appeal.
My lords, my grandfather, one Kamari Gowda, my lords, he had purchased a land bearing survey number 84 measuring 5 acres.
No, in this notice is not yet issued.
Notice has been issued, my lords.
Serve a copy, serve a copy. Serve one more copy.
Please, my lords, I'll serve, my lord.
Petitioner to serve a copy.
I'll serve it now, my lords. Can it be taken up tomorrow, my lords?
Fresh matter it is.
Yes, my lords.
Relist the matter. What are you seeking?
I'm seeking mandamus, my lords.
On the basis of?
A registered sale deed, my lords. My grandfather had purchased a land.
Copy. Now we can only issue notice and then fix in preliminary hearing list after vacation. They are seeking for transfer of revenue entries on the basis of registered document. AGA accepts notice for the respondents. List the matter in the preliminary hearing list in the week commencing from.
12th of January.
Serve a copy.
Please, my lords.
45.
Yes.
The state has filed appeal against the order of the Special Deputy Commissioner.
Lord, your lordship may see my prayer mullets for a second. Lords, all that I am seeking, Lords, is implementation of the order passed by the special DC. The order, Lords, was passed on 6/5/2024. Now, Lords, they say an appeal is filed. This is an order, Lords, that is passed under 67(2) of the Karnataka Land Revenue Act. Now, Lords, the only remedy available for them is to file a suit under 67(3) before the civil court. Lords, that is one issue.
Okay, that provision now there's some amendment.
Lords, I'll come to that. Lords, the amendment is brought about after passing of the order passed by the Deputy Commissioner. It is not before. So, Lords, the amended provision will not come into effect. They will necessarily have to file a suit for declaration.
That let us see.
Lords, that is one issue. The other issue, Lords, they can't take a stand now saying an appeal is filed when all that I am saying, Lords, is implement this order. Lordship may pass an order saying implement this order, and Lords, I will await the outcome of the suit. But until then, Lords, this order is in force.
Now you place that on record, whatever you have filed.
Just a copy of the revision petition. Also serve the copy on the petition.
AGA files a memo.
Lords, your Lordship may see this one judgment that I produced, Lord.
Let us see, let us see.
No, Lords, the coordinate bench, Lords, has already passed an order. Lords, directing the respondents to implement the order passed by the special DC. That pertains to survey number 47. Lords, this pertains to survey number 48. Now, Lords, a similar order if passed. Lords, all that it'll do, Lords, is implement the order of the special DC and change the revenue entries in my favor. Now, Lords, what they've done, they filed an appeal, Lords, before the KAT. When, Lords, they had to go before the civil court, even as per 67(3).
That
So
means-
until that is done, my lord, this order has to be implemented.
Let us see, let us
My lord, and this matter, my lord, has come up for the past 8 occasions, my lord.
Maybe, but until that attains, no hurry, finally dispute has to be settled. Now, if it's dismissed, there ends the matter, you'll have to wait.
My lord, even if it gets dismissed, my lord, this order will be hanging on me. There is no implementation of this
If
order.
it is set aside,
My lord, it can't be because
that
the
which,
provision.
that which AGA files a memo and produces copy of the order, a copy of the
Petition, my lord.
petition, revision petition filed before the Karnataka Appellate Tribunal, calling in question correctness of the order dated 6/5/24 passed in RRT 2 ECR/17/23-2024. Relist the matter in the week commencing from
12th of January. 12th of
You take your chance, we'll see. Yes,
46,
Plus, my request to date be fixed at least.
date,
yes. 14,
yes.
46.
46 not again. But I'm only seeking malad. Non by virtue of malad the sale deed I become the owner. But Kata is my name as per the Assistant Commissioner order. And now malad I filed an application for Tatkal malad the podi. Now endorsement has been given malad some malad the BBMP last the dumping of malad the wastage. Lari ನಿಲ್ಸಿರ್ತಾರೆ malad the ವಿಲೇಜರ್ಸ್ ಹೇಳ್ತಾ ಇದಾರೆ ಇದು ಬಿಬಿಎಂಪಿ ಯೂಸ್ ಮಾಡ್ತಿರೋ ಪ್ರಾಪರ್ಟಿ ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ ಇಸ್ ಅ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಾನ್ ಮಾಡೋದಕ್ಕಾಗಲ್ಲ ಅಂತ ಹಿ ಹಸ್ ಗಿವನ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಮಲಟ್ ದೇರ್ ಇಸ್ ನೋ ರೆಕಾರ್ಡ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ತಾವು ಹೇಳಿದ್ರಿ ಅವ್ರಿಗೆ ಈಸ್ ದರ್ ಎನಿ ರೆಕಾರ್ಡ್ ಟು ಶೋ ದಟ್ ಎನಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ತತ್ಕಾಲ್ ಪೋಡಿ ನಂದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟು ಸುಮ್ ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ದೇರ್ ಇಸ್ ನೋ ರೆಕಾರ್ಡ್ ದೇರ್ ಇಸ್ ನೋ ಸ್ಟೇಟ್ಮೆಂಟ್
There are some instructions. I'll need some time. I have not.
Monday. Relist the matter in same stage on Monday.
Please.
My lord, I appear for the petitioners in these batch cases, my lord. My only request is to consider my application, my lord, for executing a lease agreement, my lord. Last occasion, they have taken time. And this honorable court has already considered, my lord, similar such a writ.
My lord, the state was directed to take their stand in writing. I have not yet received instructions. What should I have it in January, my lord?
My lord.
Let us see, let us see.
My lord, I am only, whatever they want to say, let them say it in writing, my lord, to me.
That's
I
what.
only want disposal,
Fix a
my lord,
date.
of all these writ
Correct,
petitions.
fix a date. Let them take the
Nature of
stand
writ
in
of
writing.
mandamus.
No, let them take the stand in writing. They want to take the stand. Let them take, then we'll see what is to be done. AGA submits that statement of objections would be filed within
2 weeks.
2 weeks. Relist the matter in the week commencing from
12th of January.
No, it will be too late, my lord, sir. In an earlier date, my lord.
No, very 12th.
19th of January.
Yes.
No, I am only requesting for earlier date, my lord.
Not before vacation, not before vacation. Yes.
At least in the first week, my lord, first week of Jan.
48.
First week of January, my lord.
Yes. Yes.
48, Vinod. 48. Yes.
Relist the matter
Vinod Reddy.
in the week commencing from
19th of January. 49.
Petitioner.
Huh.
That comes to consumption scholarship.
They want to withdraw. Put it. Put it.
Even that second case they are withdrawing, my lord.
Second only.
Your Lordship.
There, your Lordship. what
Education
we are
matter may be.
What happens, your Lordship, in the suit also we are.
Counsel for the petitioner. 49.1 is delinked. Memo is filed.
Lordship, in the prayer, some more documents are there because on the when in the 1885.
Rejected. I am not going to permit you to withdraw. Memo for withdrawal is rejected as grounds are not grounds made out are not do not make out a legal case for permitting withdrawal with liberty to file afresh. Full stop. It is noticed that the present petition.
Cause of action we prefer.
It is
Without
noticed
liberty,
that the present petition is linked to WP 26604 of 2025. Full stop. The question of renewal of recognition is a subject matter in WP 26604 of 2025, while WP 13346 of 2022 relates to land which the state submits has not been lawfully transferred to the institution. Full stop. Noticing the nature of dispute and that the question of recognition is still pending consideration, which is a subject matter of WP 26604 of 2025. The question of permitting withdrawal of 13346 of 2022 with fresh liberty cannot be considered. List the matters in the week commencing
Your Lordship,
from.
kindly have it tomorrow, Your Lordship.
No.
Your Lordship, urgency. Your
No,
Lordship.
I'm sorry.
Your Lordship.
Until 49, until the land is clear, I'm not going to pass any order on
Kindly.
recognition. Yes.
Land,
You want to argue on the land, you argue.
land.
You want to argue on the land, you argue it today. Yes. Next.
Your Lordship, interim order may be extension, Your Lordship.
Interim orders in operation is extended till the next day.
Date may be, Your Lordship.
Yes. Second week of January could.
First week.
No. This is without your squatting on government land. And what is this tamasha?
No, your Lordship.
No, Kodi, I'll dismiss the writ petition. There's nothing in that. Kodi. 49.1 Kodi. Now you make out your case.
Lordship, there, at least legal.
Under what?
Permit me to-
I'm hearing you. Now you tell me under what law you're seeking for grant of land.
There, only thing is that your Lordship, there, government also at the time of 1985 issued one letter permitting us to that. Based on that only we filed the suit and got the injunction. So what we want is that instead of seeking for the entire amendment, we sought for the withdrawal and filed the fresh petition.
I'm not.
Your Lordship, let it permit me to withdraw without liberty. We will pursue the same in the suit itself, Your Lordship.
That is okay. Then you file a memo.
Sir,
The
there,
petitioner files a memo and submits petition may be dismissed as not pressed. In light of the same, is dismissed as not pressed. All contentions are kept open. 49.1 delinked and disposed of. 49 to be listed before the
regular
roster bench.
Lordship, kindly have it tomorrow, Your Lordship, urgency. Lordship, urgency.
Remove the registry, remove a memo there.
Kindly that may be mentioned.
Remove a memo.
50,
Yes.
50 Ravi HK.
50, if Your Lordship could have it next week, my Lord, I'll get instructions.
Relist the matter in the week commencing from.
5th of January.
Yes.
51 Pradeep, yes.
in 49, I'll not press the earlier memo instead of that judgment.
Correct. So you give this not, give,
I'll
give,
give
give
that
the
memo
fresh
also,
one.
not
Give the
press.
fresh one.
51.
And for petitioner, seeking the prayer for issue of writ of mandamus, direct to the respondent number 2 to consider the application of the petitioner at annexure A. This annexure A is annexure ತಾತ್ಕಾಲ ಪೋಡಿಗಾಗಿ ನೀಡಿರುವ ಅರ್ಜಿ annexure A, page number 12 ಮೇಲೆ
You are seeking for
writ of mandamus.
It's acquired, is it? Acquired. Then you place it on record. Relist the matter in the week commencing from.
12th of January. 52? 52 Abdul?
But let's I'm a senior citizen. I'm seeking the cancellation of my conversion, wherein my children have taken my signature and got the conversion done. If I go to the senior citizen court also, I'll get the remedy, my lords.
Yes.
So I'm knocking the door of the writ court to.
Just wait.
Once an order is passed by the deputy commissioner, it becomes counter issue.
Okay.
Not possible to review or recall. Can also review the judgment.
But let's, since I'm a senior citizen, I have.
Oh, correct, 1 minute. Now who is the owner of the property?
The petitioner, my lords.
On their request, the land.
They have taken my I am a senior citizen. I do not have knowledge. My children have taken the signature and have got the conversion done, my lords. So I'm not in a position to pay the taxes now, my lords. So this honorable court has the powers, my lords. I'm not knocking the doors of the writ court because the law also permits me, because I'm a senior citizen. They've taken the. So kindly have mercy on me. I'm in the fag end of my life, my lords. I cannot keep roaming to the KIT.
No, now they
My
have
lords.
sought for conversion. No doubt as the administrative authority, you may not have power. But if there is no further development of the land pursuant to the order of conversion and no change in the nature of property, property is vacant.
Vacant, my lords.
In writ jurisdiction, let us see. I'm saying unless there is something that is created in the interregnum between the date of conversion. Suppose they have made some sites.
Nothing, my lords. It's still.
1 or 2 sites sold, etc. Yeah, if the status of the property is the same, it will not cause prejudice to you. No, but you're saying he doesn't have the power, then correct. Correct. So that is on merit, sir. So he has no grievance against the order. He's only saying, please withdraw it. So if there is no change in the nature of property, we can consider it and then set it aside and leave it. If he wants next time, let him convert it. If there are any dues, then it's for him to clear it. Henceforth, he would be free from this, and we set it aside. Under 21 of the General Clauses Act, you have the power to cancel it also. General Clause Act, Podi. The power to pass an order will include the power to cancel it. Just check on your mobile, section 21 of General Clause.
21.
We have a separate state act, is it? Separate, separate Karnataka General Clause Act is it? Separate again. Karnataka antill. You have a state act, is it? Huh? Mysore. Mysore General Plaza Act. Just see 21.
Power to issue, to include, power to add, to amend, to vary, rescind, notification, order, rules and bylaws.
So we can observe that you have the power to rescind. It's not in the nature of a
Yes,
review.
Lords. Powers to
Making it. So you consider it and pass order. The petitioner submits. The petitioners have sought for setting aside of the impugned conversion order dated 10/1/2024 issued by the first respondent. It is the case of the petitioner that though conversion of land was sought for residential purposes, however, due to practical difficulties, including inability to pay taxes and maintain the land and use it for residential purposes, petitioner desires rescinding of the order, and in light of which petitioner had made a representation at Annexure B. Annexure D.
Annexure D, my lords.
D. Full stop. The representation at Annexure D would reveal that petitioner has sought for cancellation of the order of conversion. Full stop. While
Annexure
AG
B, order conversion, annexure B, my lords.
Cancellation of the order of conversion enclosed at Annexure B dated 10/1/2024. Though AGA submits that power once exercised in an administrative capacity exhausts itself, however, in terms of Section 21 of the General Clauses Act, the power to make an order would include power to rescind an order. Full stop. Further, it is noticed that even the order of conversion imposes conditions for violation of which the order of conversion could be cancelled. Noticing the power conferred under Section 21 of the Karnataka General Clauses Act, it would be appropriate to relegate direct the Deputy Commissioner to dispose of the representation at Annexure D within a period of
15 days, my lords. I'm a senior citizen.
within a period of 1 month from date of receipt of certified copy of the order. Now, if they want to cancel it, it goes back to agricultural land. Unless there's an impediment, you consider. The DC may take note of the plea of the petitioner, and if there is no impediment, may consider invoking power under Section 21 to rescind the order. Yes. Accordingly, petition is disposed of. Yes.
53. My lord, I appeal for the petitioner. I only want my representations, my lord, to be considered for change of khata. the name of the state government, my lord, is mentioned, and which I wanted it to be cancelled, and my name should have been entered in place of my father.
Their claim is with regard to succession. Now, what has happened in RTC, it is reflecting as Sarkara. And, my instructions will not, by Monday, I will get a clear instruction. Will be taken up on next Wednesday.
At request, AGA relist the matter on
17.
yes.
54.
54, my lord, start for writ of mandamus. Deputy Commissioner has passed an order under 136(3). There, my lord, the Tahsildar has now challenged that order before the Regional Commissioner under section 56. It is pending there. Therefore, we are unable to act upon till that appeal is disposed of.
So the 27/3/25 order.
Yes, ma'am.
Huh?
Yes, ma'am.
No, that is pending before the regional commissioner.
Yes, ma'am. Under 56.
So then you'll have to wait
it out.
Await the outcome of that. The petitioner had sought for issuance of writ in the nature of mandamus to respondent number 3. Tahsildar Yelahanka to consider representation dated 4/4/2025 at Annexure J. Petitioner had also sought for implementation of the order of the Special Deputy Commissioner at Annexure H.
H45.
Annexure H is the order of the Special Deputy Commissioner in RRT 2 NA CR 56/2024-25 passed under 136(3). In light of full stop. Next, AGA upon instruction submits that the order of the Special Deputy Commissioner of 27th March 2025 is a matter of adjudication before the Regional Commissioner under section 56 of the Karnataka Land Revenue Act. You just furnish the details, number.
I'll furnish it.
In light of the memo filed and said submission, petition is disposed of, reserving liberty to the petitioner to make fresh representation to the authorities once the proceeding before the regional commissioner attain finality. All contentions are kept open.
Direction to Regional Commissioner to dispose of the matter expeditiously.
This
is of the SLD of the year 1979.
Regional Commissioner may expedite the proceedings pending before it. Yes.
55.
See that he's not arrayed as a party. I'll anyway not convey. Expedition of the SLD of 79.
Let us see. Yes.
It's a podi proceedings, my lord. My application is pending since from 6/7/2020.
The land has been converted, is what my oral instructions are, my lord, that I received today. I'll have to place that on record.
So then it will be out of our
I have already
jurisdiction.
decreed, my lord.
Out of our jurisdiction.
City
limits.
So you find out land has been converted, is it?
No, my lord.
Sites are formed is what I'm told.
So you find out. Relist. Let them find out correctly. Otherwise,
sorry, my lord. I'm sorry, my lord. 55, 56.
This is 55.
Sorry,
The agricultural land.
Sorry, my
lord.
Then agreement of sale, my lord. And based on the agreement, my lord, the decree has been passed by the
specific performance.
Yes, my lord. So application was pending since 2020.
Yes, madam. Still is the matter in the same stage on.
17.
Yes.
56. Adinarayana.
From last 1.5 year, this matter, my lord, the land has been converted is what my instructions
But and all cancelled by the KAT and the DC, Assistant Commissioner, every but he cancelled the revenue records, changed in the name of Madhurama and others. All the orders produced before this honorable court. The Tahsildar is no way concerned about the conversion order or farming of the layout. Their duty is only to reinstate the revenue records into the name of my grandfather. That is my representation. Even the deputy commissioner also is ordered to direct the Tahsildar to change the revenue records into name of my grandfather.
Where is that order?
The annexure B, in page 16.
No, but this is your own letter. Annexure B.
Annexure B.
We will dispose it off. The petitioner sought for issuance of a writ of mandamus to consider representation dated 18/6/24 and implement direction issued by the Deputy Commissioner dated 16/9/2025. In terms of Annexure B, which is a communication by the Office of the Additional Deputy Commissioner to the Special Tahsildar Anikal Taluk. It is seen that in terms of the order of the Karnataka Appellate Tribunal as well as orders of the Deputy Commissioner and Assistant Commissioner, there was a direction for restoration of entries in the name of Muni Kavirappa, son of Chinnappa. And as the said representation has not been considered, the Special Tahsildar was directed to consider the same. Such communication is dated 16/9/25. In light of the limited prayer sought for and also taking note of the order passed by the Karnataka Appellate Tribunal, which has dismissed the appeal filed by Madhurama, and noticing the order of the Deputy Commissioner, which also had dismissed appeal filed against the order of the Assistant Commissioner. Where is the order of the AC?
AC is the annexure.
Annexure?
Annexure D.
Page?
Annexure F at page 22.
In ಬರ್ತಿದ್ದೀರಾ? As also noticing that the Assistant Commissioner had dismissed the appeal filed by Madhurama, the representation at Annexure A to be considered and appropriate orders passed within a period of
4 weeks.
4 weeks from date of receipt of certified copy of the order. All contentions are kept open.
57, Sheshagiri Rao. 57.
Relist the matter.
Report has been filed, my lord.
Huh?
Report has been filed on the 2nd.
The
Just hand over a copy.
Tahsildar report has been.
You go through it. Go through it. Report of the filed by the Tahsildar placed on record. Relist the matter in the week commencing from
12th of January. 58. Lakshmipati Reddy, 58.
Petition for a writ of mandamus for a direction to conduct podi and assign the number. My lord, kindly refer to page Annex C, page number 35, my lord.
Yes.
Page 35. There was an order last minute, page 35. There was an order to conduct podi and also assign sub numbers by the Tahsildar in the Annex C.
Yes, yes.
Subject to disposal of the OS number
So this was,
681 of
they
95.
made an application under the old survey number and not the new one. That's one point. Second is, my lord, there's an inquiry that is going on in relation to this before the regional commissioner. Therefore, my lord, we are not able to execute and process this.
So find out and then you put your stand in.
I'll take it in writing.
EGA, you take the stand in writing in 2 weeks. Relist the matter in the same stage on in the week commencing from
12th of January.
12th of January.
59.
Yes.
Lokesh or
For petitioner.
Yes.
My lord, in this third time matter has been listed, only
They want to file objections. Let us see, there must be some issue. There must be some issue.
no,
EGA.
order sheet also speaks that I have filed my objection. I have placed documents. If order is set aside and the matter is remanded back, I will proceed with the matter, my lord. Because your honors may kindly turn to
Where is the,
order sheet, my lord.
yes,
Page number 100, which is the typed copy, my lord.
page?
Page 100. Typed copy, it is a typed copy, my lord, wherein the order sheet itself says that I have filed my objections.
On which date?
Yes, my lord.
Which date you are referring to?
My lord, 19/6/23.
19?
6/23.
Page?
My lord, order sheet page is at 89, my lord. Typed copy of the order sheet commences from page 98, my lord. 98, my lord, 10/11/2010. ಪ್ರಕರಣವನ್ನು ಕೂಗಿಸಿದೆ. ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರುಪಡಿಸಿರುವ ದಾಖಲೆ ಹಾಗೂ ಆಕ್ಷೇಪಣೆ ಮೇರೆಗೆ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲು ಕೋರಿದ್ದಾರೆ. ಆದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಿದೆ. And documents which I have placed on record, my lord, commences from page number 74, my lord.
Page?
74 is the LR application because proceedings was initiated against a dead person. Page number 77 is the objections, my lord.
So we can dispose it of directing them to redo it.
Yes, my lord.
Relist, date code, same stage on. You just ask them that since the order sheet says that they filed the documents and the finding in the order is they were not participated. So we'll remand it, keeping open all contention.
17.
Yes.
17. 59. 17.
Obliged.
Huh. 59. Yes.
60.
Please.
Nataraj SC 60.
Writ of mandamus based on the sale deed and authorities orders, please, my lord.
60.
Please.
The present petition is filed seeking for issuance of it in the nature of mandamus. Direct respondents to consider representation at Annexure A dated 19/9/2025. AGA submits that the request of the petitioner would be considered regarding transfer of kata and appropriate orders passed
Please. Mutation is already
in a
registered.
period of 2 weeks. So in light of the same, noticing the stand of the
Mutation is already registered.
petition is disposed of. Yes.
Please, with
61,
within 2 weeks.
Venkatesh Murthy.
Oblige.
Petitioner is Madam Lord.
Yes.
The matter relates to 2 acres, 20 guntas of land in survey number 180 in Chikmagalur, Tarikere Taluk in Chikmagalur district. Ma'am.
You are the purchaser.
No, my lord. I am the original grantee. I am the descendant of the original grantor. Grant.
What are you seeking?
My lord, I am only seeking restoration of the granted land, my lord, in my favor.
So
Further
notice,
to the orders,
notice must,
further to the orders of this court itself, my lord.
So now
Honorable court.
the orders of the AC is in your favor.
Please, my lord, as well as the DC,
That
my
has
lord.
to be implemented.
Please, my lord. It has also come up in appeal. It has come up in 2 separate writ petitions before this court as well as writ appeals, my lord.
Yes.
And in each instance, my lord, it's been in my favor, my lord. The respondents at this point of time, my lord, are obstructing my possession of the property by filing complaints against me and misusing the machinery of the local authorities, my lord.
61. 61. So first time it's coming.
Please, ma'am.
AGA.
It had come up on the last date, my lord. There was one office objection that we had to comply with,
No, correct.
which we have.
AGA accepts notice for the respondents.
My lord also sought an interim relief, my lord, that the Bagerukum committee, my lord, may not make any changes to the revenue records until, and my lord, I may be permitted to harvest my crops, my lord. The crops at this point of time are getting spoiled, my lord. I have areca and coconut growing over there.
Where is the order of the land must be restored to you?
Already restored. It has already been restored as of 89, my lord. I have been in possession, my lord.
Then what you are seeking?
I have been forcibly.
Okay, what are you seeking then? If it's
My
restored
lord,
to you.
what has happened at this point of time, my lord, is that they have the respondent number 9 has also filed an application before the Bagerukum committee, my lord, which has been rejected on 3 separate occasions. Now, using that application, saying that I have filed an application, he has filed complaints against me, my lord, and then gone ahead and filed an original suit as well against me, my lord. If my lord may look at annexure O.
You take out notice. AGA accepts notice for respondents 1 to 8. Emergent notice to the 9th respondent. There will be an order of maintaining of status quo regarding possession as on date.
My lord, in interim protection may be
I
granted.
said status quo regarding possession.
62, Narsimurthy.
Yes.
Petitioner, my lord, for writ of mandamus to consider the representation dated, my lord.
The suit for partition that's pending. Also, my lord, again, the survey number in which they've applied for and the survey number that is existing are different.
So then you take your
Take a stand in writing.
AGA is directed to take stand in writing within 2 weeks.
63,
Yes.
Rajbala.
60 date, my lord.
Relisting week commencing.
Submission, my lord.
Yes.
My lord. Serial number 15, interim order needs to be.
They'll interim order it.
Serial number
59.
12. 63, Nataraj Balla. 63.
This matter of filing impleading application. Impleading application for the villagers, my lord.
Serve a copy. Serve a copy. The filing impleading application. The application for impleading file is taken on record. Copy to be served on counsel for the petitioner.
Sir, already served. Copy, sir.
Have you served?
Yes, sir.
Relist in the week commencing from
12th of January. 64,
Lord, I pay for the petitioner, my lord, seeking writ of mandamus That seeking writ of mandamus to consider the representation annexure Q, my lord, for issuance of computerized RTC.
Lord, there has
In
been
terms-
tampering in the record rooms in the taluk.
State to take the stand in writing within 2 weeks.
Please.
Relist the matter in the week commencing from.
15th of January.
Yes.
Orders matters, seal number 73.
65, my lord.
Wait.
65 and 66, your lordship may have it next week, my lord. Mandamus also, notice has already been given to the government.
Lord, there is 65 and 60, just one submission. Their application is not found. If they make another application, we'll consider it.
Your lordships can
Application is not found.
direct us to file a fresh application on
application
and
can be
let them
filed,
consider
my lord,
within 3 months.
Their applications are not found for podi and duras.
List in fresh matters list tomorrow. 65, 66. Yes.
67
Take out notice. Steps.
ಆಗಿದೆ ನೋಟಿಸ್ ಆಗಿದೆ ಶುಕ್ರವಾರದಿಂದ ನಿನ್ನೆ ಹಾಕಿ ನಿನ್ನೆಯಿಂದ ಇವತ್ತು ಬಂದದ್ದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ only 2 points my lord. It's a order passed by the signed by only the chairman, other members have not signed.
67. Order of the tribunal.
Order of the tribunal at annexure A, my lord, page number 20.
My lord, I am for the caveat respondent number 1. Kindly have it tomorrow. Senior is on legs in Kotal 5.
Relist the matter in fresh matters list tomorrow. Yes.
Serial number 89, my lord.
Yes.
So for consideration of interim order, notice are awaiting. Kindly have it on Monday, my lord.
Dates, you can ask the court officer.
Monday, my lord.
85, my lord. 85.
69.
Stay
Serial
express
number
today.
69.
Wherever there is interim order, it will stand extended.
Lord, 69, I want to increase
69.
myself. The deputy commissioner and Tahsildar.
File it in the office.
Very good, very good. In the 69, the Tahsildar and deputy commissioner has to file the affidavits today.
68 also, my lord.
69. That is mutations.
And Tahsildar have to file an affidavit. Ready, my lord, we will file it in the office and we'll serve a copy now.
The same with 68,
That-
my lord.
Both are ready.
Serve
Interim order
copies.
may be extended.
Serve copies. And
Interim
two-
order may be.
That
Wherever interim orders are there, it will stand extended.
and date may be my lord 69.
Where they are affidavit and title.
69. In the remaining mutations, my lord, effected
My lord,
on 130
68.
PM.
Yes, see, dates will be
It
given.
also dates.
Yes, yes.
21 lots I have not for protection but to harvest.
17.
The honorable court was pleased to direct
17.
me to serve the
17.
notice to the council appearing before the land tribunal. I have served the notice. The moment I served the notice, my lord, they cut and removed the standing crop forcibly, my lord. Now, my lord, the crops are with the custody of the respondent, my lord, respondent number 4. The problem I am facing.
Tomorrow in the fresh matters.
Intimate the date also. my lord.
Tomorrow in fresh matters.
63, my lord.
Bill number
23.
72, my lord.
May I make a mention? The others dates will be given.
My lord, serial
Lord,
number
may I make a
72
mention
is
on
the
one
MTB
matter?
matter in which an SOP is sought to be filed. The SOP has been, the draft SOP has been filed by us. Has to be considered by this court. But
Let us.
Serial number 97, my lord.
Not eight.
That's
May I make a
87
mention?
minutes.
Others, please ask, get your dates.
73.
Allah, 97, my lord.
87
All
minutes.
dates will be given.
Allah, what had happened?
We'll see now, not now.
Your lordship
I have an
kindly-
urgent bail matter. So I can't spend any time.
Allah,
Dates-
97, what had happened?
Let us see, not now.
Allah, there was a conditional order to Tahsildar. They have violated they have went into the land and changed the nature of the land. Tomorrow, my lords, urgency is there. my lord. We have filed complaint also, my lords.
It will be taken.
That's
Tomorrow.
87.
Your lordships had occasion, my lord, to see it
97.
once before.
Wherever interim orders are there, it will stand extended.
That's serial number 87.
Could your
Serial
lordships
number
not give a short
87,
date?
next week, anytime, my lords.
You ask the
I'm
court
pressing
of-
for an interim order in this matter.
You ask the court officer, it will be given.
Please.
Serial number 81, my lord.
Dates you take. I'm not in a position to take up any matter now. There's an urgent bail matter. I have to take it up. Dates you take, I've asked the court officer, he'll give you dates.
My lord, in serial number 98, one matter needs to be connected, my lord. Serial number 98.
Just give the
Yeah,
rec number.
WP 13643 of 24, my lord. WP 13643 of 24. In serial number 98, my lord.
Yes.
Lord, SVM?
Yes, start.
Yes,
Arvind.
page, if I may
Yes.
do a quick recap of my submissions. Lord, I had taken your lordship through the legal regime and particularly emphasized on sections 22, 23, 24, which are special provisions dealing with money laundering. And thereafter, I had taken your lordship through certain parts of the complaint that was filed. And I had stopped at page number 25, the prosecution complaint.
Yes.
But I had read out certain parts of the prosecution complaint. The last paragraph that I had read was 11.3 at page 24 of the complaint. Now, if your lordships would kindly take up page 25 of the prosecution complaint. Para 11.4 says a case-wise discussion of the proceeds of crime, that is illegally allotted MUDA sites related to the scheduled offense, is elaborated in the subsequent paras. So there are about 4 or 5 different clusters. One is a group of sites were allotted to one Ravi Kumar. Then another group of sites were allotted to one Abdul Wahid. And then there is one batch of sites which were allotted to a Chamundeshwari Sangha. And then there is one more. There are about 4 or 5 clusters. I will quickly take your lordship through what is the material available on record to show that there is generation of proceeds of crime in respect of those allotments. 11.5 pertains to illegal allotment in the case of Shri M. Ravi Kumar and others made by GT Dinesh Kumar. A total of 31 sites have been allotted illegally by Dinesh Kumar. In the case of M. Ravi Kumar, M. Raju, Mahesh, Sujata Kumari having address at so-and-so. Details of the sites allotted as compensation for land measuring 5 acre 9 gunta at survey number 77 of Belavatta villages as below. There is a list of the name, the site number, the layout, all of them are accommodated in JCST M block Kuvempunagar, and the date of allocation is also common. It runs into 31 sites. Below that, my lord, if your lordship would now turn to page 28, there is an analysis. Above sites have been allotted as compensation in lieu of land acquired by survey number 77 under 50-50 scheme in the name of Ravi Kumar and others. Investigation conducted under PMLA revealed as under. As per preliminary notification issued for the acquisition of the above land, above mentioned individuals are not the actual landowners. Ravi Kumar and his relatives did not have any document with regard to ownership of 5 acres. Ravi Kumar was approached by an individual named Shivanna in 23. Shivanna told Ravi Kumar that land belonging to his family was acquired by CYTB in 1966. Shivanna told him that he will obtain the compensation for that land and Sri Ravi Kumar will not get compensation if he tried on his own. Shivanna made Ravi Kumar and his relatives, namely Sujata and others, sign one GPA for sale of the sites after obtaining the same from MUDA. Each family members were paid 5 lakh each, that is total of 25 lakh in cash. In this regard, statement given under section 50 by Ravi Kumar on 29 and 24 is placed as relied upon document 16 and the statement given by Shivanna under section 50 on 19/11/2024 is placed as relied upon document 17. So if I may pause here, the modus operandi is like this.
Same with BDA, incentive schemes, incentive sites. Suppose land is acquired and they have to give 1 acre, 1 site. Same modus operandi. The genuine landowner.
No, this is even more blatant. So what they do is, they just skim through the documents. They go to 1966, not more than almost 60 years ago. They find that there is nobody. So they set up somebody. They say, you claim that you are the descendant of so-and-so. Because at that point of time, CAT probably would not have paid any compensation, or compensation was paid, there is no evidence. So therefore now they fictitiously create these people. They take GPA in advance from him. In advance, he executes GPA that whatever site is allotted, I will sell to so-and-so. They pay him 5 lakhs and for them, I mean, for that fellow, he is getting 5 lakhs and he'll get more. And we will see later
that all these sites will come back to the relatives of GT Dinesh Kumar. Item C. Investigation reveals the following irregularities in the allotment. Allottees of Muda sites are not the landowners. Allottees have not submitted any document pertaining to the ownership of the land, such as RTC, encumbrance, legal heir, certificate, family tree, consent. Compensation is being effected for the land acquired in 1966, during which period Karnataka Urban Development Authorities so-and-so rules was not in force at the time of acquisition of the land in the year 1966. Further, para 3, page 3 of the sale deed for registration of sites in the name of allottee says the deed is subject to restrictions and conditions laid down in the CUDA rules, which is totally incorrect. Allotment of sites as compensation in lieu of land acquired does not fall within the purview of the said rules. Scrutiny of the allotment letter issued in the case reveals the following. Now, please direct attention to the allotment letter signing date and the last column, drawing of the bond paper. Now, my lord, when Muda, they issue the allotment letter, in order to ensure that there is no fraud, the government has said you have to issue allotment letters only in high security bond paper. The all letters of allotment must, otherwise somebody will create fake allotment letter. Now these high security bond papers are kept in an inventory. There is a register kept. Somebody has to go make an application. I need 5 bond sheets. It is issued and an entry is made. Now your lordship will see that the allotment letter is prior to the date on which the bond paper has been drawn. In all these cases, at least 2 weeks prior to that. In some cases, it is 2 months. Subsequently, we will see. One more clear evidence, prima facie evidence, that these are all fraudulently created. Now, if I may move to the next page, page 30, after the table, it can be seen from the above table that all high security bond papers for making allotment in the case have been drawn from the store subsequent to the date of the sign of the allotment letter. Further, search in the case of M. Ravi Kumar also revealed he and his family members Sujata Kumari, Mahesh and Raju have signed an irrevocable GPA which states that Muda sanctioned sites in different dimensions after developing the layout in the said land, that is 5 acre 9 guntas of land in 77 Belavatta village, and shall be obtained in the name of GPA holder Baswaraju and Satish V. This irrevocable GPA executed on 7/8/23, that is more than 1 month before the allotment of Muda sites. A copy of the above GPA was submitted by Ravi Kumar during the course of the statement recorded under 17(1)(f) on 28/10. Further, irrevocable GPA has been signed for an amount of 3,65,75,000 by Shri M. Ravi Kumar and his relative through his bank account in Karnataka Bank. Analysis of the said bank account reveals that the entire amount of 3,65,00,000 has been routed through the bank account and taken back by Basuraju, Satish, Shivanna and other associates. Details are as below. Your lordship will see here that if you see number 1, on 19/8, there is an amount credited in Ravi Kumar's account, 50,37,500. And about 2 days later, there is a withdrawal of 15 lakhs in the name of Shivanna. 5 lakhs is further withdrawn on the same day in cash. Another 5 lakhs withdrawn in cash by Hemant Raj. Another 15 lakhs is paid to Rajeshwari, and another 10 lakhs on the very same day, 2 days after the deposit, it has gone there. So I've given the description. Who are these people? These are all people who facilitated the deal. And then on 14th of December 2023, another 65 lakhs is deposited. 2 days later, almost all of it is gone. 19th February, 60 lakhs is deposited. Next day, entire amount is gone. It has gone back. So in all these 3 crore has come and gone, only records created. And if I may read the next page, it is observed from the above GPAs, from the above that the GPA has been signed on 7/8/23, and the sellers Ravi Kumar and family members, that is so and so, stated that they have received 3,65 lakhs. However, it is seen from the above that no consideration has been paid at the time of signing the GPA. Further, the entire money has been routed through the bank account of Ravi Kumar and received back. Hence, it is evident that the GPA signed is a sham transaction which was used to layer the illegally obtained sites and transfer of ownership to M. Baswaraju and V. Satish, who had all along characterized the illegal allotment. I'll pause here for a moment. For us, this creation of these layers, straight away it falls under section 3, because you are trying to legalize the amount. You are trying to give an impression that it is untainted money. You show it as a consideration, and therefore you are making an attempt to show. So these are all straight away offenses falling under section 3 of the PMLA. And we call it as layering. You layer it to give a projection that it is lawfully earned money. And if I may continue from there, hence it is very evident that so-and-so is the above facts have been confirmed by Ravi Kumar, Baswaraj and Satish, who during the course of investigation. All these three people have made their statement. In this regard, statement given by Baswaraju on 2/12 and Satish on 14/4/12 under section 50 are placed. Further, one such allotted site which was obtained by Baswaraju and Satish through the GPA has already been sold. In this connection, it is pertinent to mention that MS Nandish, the caseworker of Muda, who dealt with the allotment in the case, stated during the course of his statement recorded under section 50 PMLA on 24/12 that neither M. Ravi Kumar nor any of his relatives ever visited Muda for obtaining compensation. He also stated that Baswaraju and Satish used to visit the Muda office and called regarding allotment in cases. So these are all evidences given by these people, the Muda clerk, the Ravi Kumar, who himself said that he was going to the Muda office. So there is a summary at the bottom. The following can be summarized by the investigation undertaken by PML. Proceeds of crime in the form of sites developed by Muda are being obtained in the name of Ravi Kumar and his relatives through illegal allotment, that is criminal activities associated with the scheduled offense. Such proceeds of crime were layered through a sham general power of attorney and transferred to the persons involved in the transaction, that is Baswaraju and Satish. These proceeds of crime, that is illegally allotted sites, are then sold and money is generated. This is projected as untainted income, as having been obtained from real estate business and integrated into the economy. Proceeds of crime in the case of Ravi Kumar and his relatives were provisionally attached, via provisional attachment order number 2 of 25, dated 17/1/25. Provisional attachment has been confirmed by the learned adjudicating authority by an order dated 10/7 in OC number 76. A flow chart of the generation of the proceeds of crime is placed below. Then in the next page, similarly, in this case, it was 31 sites. Now, the second one is of a group of 41 sites illegally allotted in the name of Abdul Wahid. Now, in my respectful submission, this is a fictitious character, Abdul Wahid. Now, I am now reading page 34. Illegal allotment in the case of Sri Abdul Wahid by GT Dinesh Kumar. A total of 41 sites as per the list below have been allotted illegally by GT Dinesh Kumar in the case of Abdul Wahid, having address at 24/3, Turabali Street, Mandi Mola, Mysore, as compensation for land acquired in survey number so and so. So there is a long list of 31 sites which is allotted in his favor, and the date of allocation is all common, 8/3 and 1/9. There are between 8/3 and 1/9, all 41 sites are allotted to him in a very posh layout called Vijaynagar, 4th stage. If I may now read page 36. Investigation under PMLA revealed land measuring 4 acre 39 gunta was acquired for the formation of Banni Mantap. B. Landowner, as per the notification for survey number so and so, is Muhammad Peer Saab. And for survey number Abdul Wahab, not Abdul Wahid. That is the landowner as per the notification, and is not Abdul Wahid in whose name the sites have been allotted. No death certificate, legal heir certificate, family tree obtained. Item D is important. Discrepancy in the identity proof of Abdul Wahid found in the file of Muda is observed. Date of birth as per Aadhaar number so and so is 26/1/1940, but date of birth as per PAN number is 19/11/1955. So there is a 15-year difference there. Investigation also revealed that copy of Aadhaar submitted to Muda for obtaining the site and the date of birth of Abdul Wahid as 26/1/1940, and the copy of the same Aadhaar submitted to Mysore and Chamarajnagar District Cooperative Society had the date of birth as 1/1/1955. So in the Aadhaar card submitted to this bank, suddenly the date has become 1955, which clearly reveals manipulation of the documents to fraudulently obtain Muda sites, which is proceeds of crime. A copy of the letter is placed below, as RUD. In addition, verification of the address of Abdul Wahid given in the Aadhaar card revealed that no such address or person existed as intimated by the Department of Post. So therefore, my lord, this could be a very fictitious person. A copy of the response received from Department of Post is placed as RUD 26. Analysis of the allotment. Here again, Lordship will notice that the date of drawing the bond paper is 2 years after the date is signed on the allotment letter. One is March, the other one is May. And if I may read at the bottom of the table, paragraph H, it can be seen that in 15 instances, allotment of letter has been signed more than 2 months before the date of drawing high security bond papers. Further, allotment of site as, this is important, item I, allotment of site as compensation under 50/50 scheme was stopped by the government by letter dated 14/3/2023. It has also been confirmed by the government of Karnataka, Urban Development Department letter dated 15/1/25 that the allotment of site under 50/50 scheme subsequent to issue of GOK letter 14/3 is not permitted. Now kindly pause on this page. Now your lordship will see this date 14/3/2023. Government said 50/50 scheme is stopped. To overcome that, the allotment is backdated to 8/3. Please see the blatancy of the illegality. It can be seen, and if I may read next page, it can be seen from the above that the allotment has been made backdated to overcome the government order, which had specifically stopped the allotment under 50/50 scheme. Entire allotment has been made under so and so. So all this shows the illegality. I'll only read the paragraph N at page 38. Proceeds of crime in the case of Abdul Wahid was provisionally attached. And there is a summary which shows how it has made. Now, if I may move on to page number 40, para 11.7, illegal allotment in the case of Chamundeshwari Nagara Sarvodaya Sangha made by GT Dinesh Kumar. A total of 48 sites has been allotted illegally as compensation by GT Dinesh Kumar during the financial year 23-24. Details of the sites are tabulated below. Now, incidentally, item 9 is a lady called Jayama, whose writ petition is also pending before the Honorable Court. So these 48 sites, full details are available. And if I may read page 42, my lord, para A, it has been revealed during the investigation that under PMLA, that allotment has been made by presenting false facts by GT Dinesh Kumar, the then Commissioner of Muda. Same has been cancelled by the government by order dated 30/11/2024. Further, disciplinary proceedings have been initiated against the then Commissioner of Muda, GT Dinesh Kumar. The same has been confirmed by Srimati Deepa Cholan, Secretary of Urban Development Department, during the course of statement recorded under Section 50 of PMLA. Lord, I mean, this is a very strong piece of evidence for me that the Secretary of the UDD makes a statement and confirms that the bail applicant before your lordship has been found to have passed irregular and illegal allotment letters and he was suspended. And the allotment made by him has been cancelled. And para B, investigation revealed that allotment in number of sites in the case of members of Chamundeshwari Sangha, the high security bonds in using the allotment have been drawn after the date of signing the allotment letter. Now here again, there is a difference. All of them are prior to the date of issuance of the high security bond. If I may now read page 43 bottom, item D. The illegalities in the allotment of sites in the case of members of Chamundeshwari Sangha were confronted with GT Dinesh Kumar during the course of statement recorded on 23/9/2025. While being in custody of this directorate subsequent to his arrest, GT Dinesh Kumar admitted that Government of Karnataka did not grant any permission to allot sites to the members of the Chamundeshwari Sangha as requested vide Muda resolution dated 21/3/2023. He did not provide any plausible answers to the fact that 3 out of 48 sites allotted in the case has been obtained by his relatives through sale agreements without paying any money, and also the fact that huge sums of money were received by his relatives from Sri N. Manjunath, who is a major beneficiary of the illegal allotment in this case. Further, investigation revealed these illegally allotted sites to the members of the Chamundeshwari Sangha have been obtained through a GPA by real estate businessman Sri N. Manjunath. In this connection, one of the allottee of the site, Srimati J.S. Sunanda, has submitted to the learned adjudicating authority that the sites were obtained by Manjunath under undue pressure. During the course of investigation, the address of the following allottees who had obtained sites in the case was found to be not available. So in order to show that the address itself was fictitious, we have prepared a list of about 16 people, and these addresses are not available. And if I may now read last two para in page 45, sites allotted to Chamundeshwari Sangha members have been transferred to close relatives and associates of the then Muda Commissioner GT Dinesh Kumar through sale agreements for which money was paid by Sri Manjunath. And then next para, transfer of sites to relative and associate of Dinesh Kumar investigation revealed that following sites which were allotted to members of the Sangha have been transferred through sale agreement registered in Sub-Registrar Office, Mysore, North, to relative and associates of Dinesh Kumar as gratification for making illegal allotment. Now, if we see, the sellers are the allottees on the next page. H.V. Babu, P.N. Jairam and Surya Kumar are the allottees. Now, they in turn sell it to Satisha, Hoysala and Vinod Kumar, all of whom are close relatives of Dinesh Kumar. There is a nominal consideration which is shown, but a much lesser amount is paid. Now, if I may read para J, investigation under PMLA revealed the following. Hoysala, BR, Satisha are close relatives of Dinesh Kumar. Shri Vinod Kumar is a close relative of GT Dinesh Kumar. Amount mentioned in the sale agreement have been paid by N. Manjunath through his bank account. The details of the payment made by N. Manjunath for purchase of the sites by relative stroke associates of Dinesh Kumar is as follows. Now, your lordship noticed that H.V. Babu, P.N. Jai Kumar and Surya Kumar are the sellers. They are the allottees, they are the sellers. Now, the amount is deposited by Manjunath, not by the Satisha, Hoysala or Vinod Kumar. And we have bank statement to establish that. Now, P.N. Jainam is an associate of DG Dinesh Kumar, who is a beneficiary. And if I may now move to page 47, the subject facts confronted with Manjunath during the course of statement recorded under section 50 of PMLA on 12/12/24. However, he could not provide any plausible explanation for the same. Investigation also reveals that N. Manjunath had paid huge sums of money to relatives of GT Dinesh Kumar. N. Manjunath was confronted with the same during the course of statement recorded under section 50 on 12/12/24. However, no plausible explanation for the payment have been provided by him till date. Details of the amount paid by Manjunath. Name of the person, Chikka Boraya, 45 lakh. Maternal grandfather of wife. These are all in relation to Dinesh Kumar. Vinod Kumar, brother of mother-in-law. Raghu, another brother of mother-in-law. He is paid 45 lakhs. Gayatri, maternal grandmother of wife, 80 lakhs. Anupama, sister of mother-in-law, 50 lakhs. Now, my lord, what happens is, if your lordship will see, most of it is all to old people. Old people, senior citizens, all them. From there, it will be layered further. They will either gift it as, to my grandson. Please notice the modus operandi for layering the proceeds of crime.
Now,
And
they were just mentioning that except GT Dinesh Kumar, nobody else is arrested. Is it so?
Nobody else is
arrested?
No, nobody else is arrested. As of now, nobody else is arrested. Not in this case, the criminal activity, by which the proceeds of crime is generated is primarily committed by two commissioners. One is GT Dinesh Kumar, the other one is DB Natesh. DB Natesh, my lord, at the stage of summons, my lord, the matter went to the Dismissal court. My lord, I will come to it a little later. The others, my lord, I mean, the others are all low-level employees who have carried out.
No, but this Manjunath also should have been subjected to some scrutiny.
My lord, the issue is Manjunath is a independent real estate businessman. Not he cannot be not the Lokayukta police has to proceed. Not I cannot proceed on my own. This Manjunath, my lord, is not a government employee. GT Dinesh Kumar is a government employee. So, my lord, he is responsible for disproportionate assets and for violation of the government rules in the course of allotment. Manjunath is a beneficiary. He is a real estate businessman. He has joined hands with GT Dinesh Kumar. And he is a conduit. My lord, he is a conduit. He is passing on. He helps in layering. Of course, in fact, I do not want to speculate, but I take what is passing in your lordship's mind. If layering is an offense, my lord, enabling a layering also, in my respectful submission, would take within the sweep of section 3. Now, if I may read further, I'm reading page 47, para 5. Further, Manjunath also transferred proceeds of crime, that is undue gratification, in the form of transfer of rupees 25 lakh in the account held in the name of Srimati Lavanya, wife of brother of mother-in-law, in Vakratunda Graha Nirmana Sahakari Sangha Limited. Investigation under PMLA, this account was controlled by Dinesh Kumar and was used to route the proceeds of crime obtained from criminal activities associated with the scheduled offence, that is illegal allotment of Muda sites. This amount of rupees 25 lakhs was further utilized for purchase of immovable property in the name of Lavanya. During the course of statement recorded on 12/12 under section 50, Manjunath could not provide any reasons for the above transfer and stated that he did not know Lavanya. Summary: it is seen from the above, proceeds of crime, that is undue gratification for making illegal allotment in the case of Chamundeshwari Sangha, have been obtained by DT Dinesh Kumar in the form of 1. Payment of consideration for purchase of immovable property in the name of relatives. 2. Transfer of huge sums of money in account of relatives of Dinesh Kumar. 3. Transfer of money into the account of Vigneshwara Bank, which are controlled by Dinesh Kumar. Investigation under PML also revealed that proceeds of crime, that is undue gratification for making illegal allotments in the case of Chamundeshwari Sangha, have also been paid to other influential persons. Details of the same are elaborated in the subsequent paragraph. Transfer of site to Shivanna. These are all not similar. These are all benefit, but the same modus operandi. I may be permitted to read on page 49, paragraph M and N. The proceeds of crime in the form of sites illegally allotted to the members of Sangha has been layered through a GPA agreement to N. Manjunath. He has been selling the sites to customer, and the money generated is being projected as untainted property or income from real estate business. Further, this money is also being routed to Dinesh Kumar through loan, advances to his relatives and associates. Also, some of the sites were transferred to relatives stroke associates of GT Dinesh Kumar and other influential persons. Further, true nature of illegal allotted sites is being obfuscated by transferring them through settlement deeds and gift deeds in the name of close relatives or relatives of influential persons as gratification for making illegal allotment. Proceeds of crime, that is sites allotted by Muda in the case of members of the Sangha, have been provisionally attached under section 5. Adjudication in OC so-and-so is kept in abeyance pending disposal of WP number so-and-so. This is also, I think, is pending before Lordship. And if I may now move to page 51, there is another cluster of about 40 sites allotted in favor of a society called Cathedral Parish Society. If I may read para 11.8, a total of 40 sites mentioned below were illegally allotted by Dinesh Kumar in the case of Cathedral Parish Society under 50/50 scheme for the land measuring 5 acres 2 guntas. in survey number 180, so and so, so and so. Then details of that is provided. The description begins at page 54 bottom, but I guess we can skip that because the modus operandi is similar. I may only read page 55, Roman 12, Roman 12, Roman 11 and 12. Statement given by Secretary to Urban Development Department, Srimati Deepa Cholan, on 3/12/24 revealed that society had not submitted any representation to Government of Karnataka. However, there was a direction that if they give a representation to the government, then there can be allotment. Now, petitioner did not even wait for it. However, Dinesh Kumar illegally allotted the above mentioned 40 sites as compensation against 5 acre 2 guntas, despite a specific order from the government rejecting the proposal of MUDA, and also fact that the society had not filed any application before the government as directed by the Honorable High Court of Karnataka. Now, I'll pause here for a moment. In fact, my lord, let me read from page 54 bottom, because there is a division bench order which I'd like to read. If I may take your lordship back to page 54, Roman 2. Final notification for this acquisition was issued on 15/4/94. Land was to be acquired from a number of people. The next page. General award for the acquisition of this land was passed and amount was deposited in court. In this regard, an objection was received from Cathedral Society after issue of preliminary notification requesting to drop the acquisition as they claim to have acquired 108 acre. WP so-and-so was filed by society. In this regard, Honorable Court directed the government to consider the proposal submitted by MUDA, which means MUDA submitted a proposal. However, government by letter date so-and-so had rejected the proposal submitted by MUDA. Once again, another WP so-and-so was filed by society. In this regard, Honorable Court directed government to take a decision within 8 weeks. Government of Karnataka once again rejected the proposal vide order dated so-and-so. Cathedral Society filed another WP against which Honorable High Court directed state government to take an appropriate decision in accordance with law within a period of 8 weeks on the basis of representation submitted by society to be submitted by the society to the state government within a period of 2 weeks from the date of the order. Statement given by Secretary UDD revealed that society had not submitted any representation to government. However, Shri DT Dinesh Kumar illegally allotted the above mentioned sites as compensation despite a specific order from the government rejecting the proposal of the MUDA, and also the fact that society had not filed any application before the government. Now, my lord, subsequently, I'll take your lordship through a division bench order, which goes from this writ petition, where the Honorable Division Bench has made remarks on how, and the resolution was passed by GT Dinesh Kumar. The resolution or the MUDA proposal which was sent to the government and the government rejects it was sent by Dinesh Kumar. And the division bench specifically mentions about this particular commissioner. And then para B, the following irregularities are observed. We can skip that, my lord. And at page 56, bottom, once again we see that in the case of Parish Society also, the bond papers were drawn much later than the allotment letters were signed by GT Dinesh Kumar. Now, if I may read page 58, para D. A search was undertaken in the case from 28/10 to 30/10/2024. During the course of search, it was revealed that illegally allotted sites, proceeds of crime, were sold by Cathedral Parish Society through a real estate businessman named Sri Jairamu. Now, there it was, what was his name? Other fellow, Manjunath. There it was N. Manjunath for Chamundeshwari Sangha. For Cathedral Society, it is Jairamu. Jairamu, wherein unaccounted cash, proceeds of crime was generated by selling the sites, which was further routed to other brokers and influential persons in the transaction. The same was admitted by Jairamu during the course of statement recorded under section 50 on 13/11/24. Proceeds of crime generated in the form of unaccounted cash was also not disclosed in the books of accounts of Cathedral Society. It has also been revealed that the sites which were not sold were transferred in the name of wife Sayana Disa of broker influential person named Santosh Sequeira without payment of any purchase consideration. in the course to frustrate the proceedings under PMLA. This was also admitted by Sri Stanley Dalmeda, Secretary of Cathedral Parish Society, during the statement recorded on 27/12/24. The illegalities in the allotment of rights in the case of Cathedral Society were confronted with Dinesh Kumar during the course of statement recorded in section 50 on 19/9/25 while being in the custody of this directorate subsequent to his arrest. He could not provide any plausible or justifiable answer for the following. One, as to how allotment was made, despite the fact that the society did not make any representation to the respondent number one, that is State of Karnataka in WP as ordered by Honorable High Court of Karnataka. Two, as to whether any verification with regard to lawful functioning of Parish Society was conducted, since the case for allotment of compensation was pending for more than 30 years. Three, as to how allotment was made in contravention of Government of Karnataka letter dated 14/3/23. Four, with regard to generation of unaccounted cash from the sale of illegally allotted site through an intermediary named Santosh Sakwera and real estate businessman named Jairamu, from whom GT Dinesh Kumar received monetary benefit through accounts held in Vigneshwara Sakar Sangha Limited. The proceeds of crime in the case of Parish Society were attached under section 5(1) dated so and so. The same has been confirmed by adjudicating authority. And then there is a summary showing the next page 11.9. Lord, these are allotments made by the other commissioner, DB Natesha, which is why we had summoned him, DB Natesha. But DB Natesha, Lord, now it is pending before division bench. We will await the orders of the court. Now, my lord, if you lordship to turn to page 67, there is the one more batch of illegal allotment. Para 11.10. Illegal allotment in the case of Srimati Neelamma and others by GT Dinesh Kumar. A total of 23 Muda sites, proceeds of crime, have been illegally fraudulently allotted by GT Dinesh Kumar as compensation in the name of Neelamma and others having address at so and so. So there is another very posh layout called Devanuru and Vasant Nagar. There it has been allotted. The more or less the same modus operandi. I would like to read page 71. Para I and J. Page 71, para I and J. It can be seen that fraudulent has been made in direct contribution to government. Para J, melody, if I may read. Digital evidences were seized during the course of search undertaken at the office of Muda on 18/10/24, which also contains WhatsApp chat undertaken by Prashant Raju, the then personal assistant of GT Dinesh Kumar, Commissioner of Muda, with an influential person named Raghavendra. The WhatsApp chat reveals that the allotment in the case of Neelamma were orchestrated by Raghavendra. It has been stated by Sri Prashant Raju in his statement under section PMLA 2002 on 25/10/2024 that the entire allotment was undertaken as directed by Raghavendra. That is, the file for compensation was put up as directed by Raghavendra and the sites to be allotted were also intimated by him. The same can also be verified by observing the WhatsApp chat and actual allotment of sites undertaken in this case. It can also be observed from correlation of WhatsApp chat and the allotment date, and that the allotment has been made backdated. That is, the WhatsApp chat was undertaken during January to March 2024. However, the allotment letters have been issued dated 26/10/2023. Raghavendra had also confirmed during statement recorded under section 50 on 12/11/24 that he had communicated with Prashant Raju through WhatsApp with regard to the allotment of the above sites. He had also confirmed that he had requested the sites to be allotted and Sri GT Dinesh Kumar had allotted the sites as requested by him. Now later we will see there is a digital evidence of that. And, so the next few pages are all various allotments. Now, for example, page 75 at the bottom, para 11.11, 11.11, is another allotment in the name of Chandra. So I will skip that. I mean, these are all some 10, 11 sites which are allotted by following similar modus operandi. If we now move to page 91, para 11.15, there is a particular paragraph on the misuse of high security bonds. On the next page, we have given full particulars of all the bonds. And if I may read para 93, investigation under PMLA revealed that high security bond paper quoted in the sale agreements are unaccounted as per records of MUDA. Further, in this regard, it has been stated by Prasanna Kumar, Secretary, Allotment, MUDA, on 28/2/2025, and Srimati Manjula, Chief Accounts Officer, MUDA, during the course of statement recorded in the section 50, that no allotment files in respect of the above sites. So two officers of the MUDA have gone on record saying that there were no files regarding the allotment. And if I may read para F, analysis of the data provided MUDA reveals that above mentioned high security bond papers were drawn from the store by Prashant Raju, who was the personal assistant of GT Dinesh Kumar. And now para H, it has been stated by Prashant Raju during the course of statement recorded in the section 50 that he had drawn the high security bonds on the instructions of GT Dinesh Kumar and handed over to him. It has also been stated by him that GT Dinesh Kumar issued allotment letters using high security bond papers which were not kept in file. So clear evidence that the bonds were drawn on the instructions of GT Dinesh Kumar. The person who handed over has made a statement under section 50. He has seen him issue the allotment letter. Please also see paragraph I. Chandra Kumar, who was the stenographer in the office of Commissioner MUDA, has also stated during the statement recorded under section 50 that Prashant Raju used to withdraw high security bonds. He will give it to Dinesh Kumar, who in turn give the high security bond to Chandra Kumar for preparation of allotment letter. The above facts were confronted to GT Dinesh Kumar during his statement while being in custody. Though GT Dinesh Kumar claimed he had allotted 83 sites to the members of Chamundeshwari Sangha, but he could not provide any answers to the fact that there are no files in the MUDA for the same. So here, there are no files for those allotments. MUDA should have had a record of that. There is no file. So the level of the crime is very deep and grave. Then para 11.16 at the bottom of page 95. Investigation under PMLA discussed in the above para revealed that proceeds of crime in the form of large number of illegally allotted MUDA sites have been derived through criminal activities associated with scheduled offence. Such proceeds of crime have been provisionally attached. A table of the proceeds of crime provisionally attached is as follows. I had heard my learned friend submit that why they could have attached, they have not attached anything. I heard him say, but I think everything, whatever is the POC, we have attached. And here we have referred to a table attaching all the proceeds of crime. Page 96, where I have provided a table of all the properties which are already attached. Then, my lord, if your lordship should now move to the details of page 96, please have a look at the bottom, page 96. Investigation under PMLA revealed the involvement of persons who were involved in the offence of money laundering can be broadly classified as follows. Number one, MUDA officers stroke officials. Number two, real estate businessmen, brokers, influential persons. Number three, private persons. Number four, business entities and cooperative societies, trusts. F. G.T. Dinesh Kumar, who was the commissioner of MUDA, was involved in large-scale illegal allotment discussed in the above paragraph. Dinesh Kumar derived gratification, proceeds of crime for making illegal allotment. Details of the proceeds of crime derived by G.T. Dinesh Kumar for making the illegal allotment are discussed in the succeeding paragraphs. Dinesh Kumar, son of so-and-so, he is resident of flat number so-and-so, Bengaluru. He is an officer of KS services from 2010. The source of income of G.T. Dinesh Kumar is from his salary from the government of Karnataka only. Further, G.T. Dinesh Kumar does not own any immovable property in his name and in the name of his immediate family members, that is wife and children. G.T. Dinesh Kumar posted as commissioner from 4/5/22 to 2/7/24. Next page, 98. Modus operandi for obtaining proceeds of crime by G.T. Dinesh Kumar can be broadly classified as follows. Number one, receipt of cash as undue gratification from criminal activities associated with scheduled offense. Number two, receipt of undue gratification from criminal activities associated scheduled offense in the form of money transfer, credit in the account opened in the name of relatives, associates. Three, routing, layering of proceeds of crime, that is illegal allotted MUDA sites through sham transactions in the name of relatives, associates, for which beneficial owner is Dinesh Kumar. And finally, four, receipt of proceeds of crime in the form of money generated out of sale of illegal allotted MUDA sites. These proceeds of crime were received by G.T. Dinesh Kumar in the form of cash, money, movable, immovable properties, etc. Such proceeds of crime were routed through relatives, associates of G.T. Dinesh Kumar in the form of immovable properties, deposits in bank, cooperative society accounts. And para 11.25 at the bottom of 98. Investigation under PMLA so far reveals routing, layering of proceeds of crime obtained by G.T. Dinesh Kumar through bank accounts in cooperative societies, movable, immovable properties in the name of following relatives. On the page 99, I have given a table of the relatives or the associates. Tejas Gowda, brother-in-law; Putte Gowda, father-in-law; Chikkaboraya, maternal grandfather of wife; Gayatri, maternal grandmother of wife; Raghu, brother of mother-in-law; Vinod Kumar, brother of mother-in-law; Anupama, sister of mother-in-law; Lavanya, wife of brother of mother-in-law; Chandan, relative; B.R. Oisala, associate; Satisha, associate; Ramesh Kumar, servant assistant. 11.26. Evidence in the form of Aadhaar card, property document belonging to relatives, associates of Dinesh Kumar have been found seized from his residence during the course of such search undertaken under 17. This clearly indicates use of relatives, associates for routing, layering, obtaining proceedings of crime. Now I heard my learned friend say they did not find anything other than loose sheets. These loose sheets are nothing but like the Aadhaar card of the relatives, which is used to generate the proceeds of crime.
We'll continue.
Yes, I believe 5 o'clock there is a.
Your intelligence is very strong.
No.
No, it's
I need no.
lighter.
Lord, would it be possible to take around 12:30 in the morning? I don't know how your lordship's board is tomorrow. Because 4:15 tomorrow, 4:15, 2:30, my lord, I have one in quota number 10. 4:15 there is a habeas corpus hearing in the chamber.
Otherwise, we'll have it day after tomorrow.
Or between 3:30 and 4, if I get half an hour, I'll come.
Latest, yes.
If your lordship will give me that liberty, I will.
Yes.
At least tomorrow I want to conclude reading the complaint, then a few legal submissions.
One point that they raised strongly, that the PMLA is not a standalone, and it is it must go hand in hand with the predicate offense.
Yes.
So they're saying if in the predicate offense the investigation has not reached an advanced stage, whether the complaint could have been filed.
Yes,
just keep that in mind.
Yes, ma'am.
Yes.
And may I have your lordship's leave, my lord? Serial number 85, your lordships had indicated it would be heard today. What has happened is, my lord, a big development has been stalled, my lord, by an interim order. And our clients, my lord, are anxious to go for the PTCL matter, my lord. I'll take only 15 minutes of your lordship's time, my lord, someday. My lord. There's an interim order operating which has stalled the entire development of 200 acres.
Noted.
Give me only 15 minutes. I don't need more than 15 minutes.
Monday, we'll have it on Monday.
Grateful, sir. Grateful.
My lordship.
List number 3, my lord. Serial number 21. 85. Odd question is involved, my lord. May I request on day after tomorrow or day after tomorrow?
We make a request to the court officer, let us see.
My
Please.
lordship. List 3, serial number 17, my lordships. My lordships, I am the inflating applicant, my lordships. My IA may be kindly allowed, my lordships.
Let us see, let us see. Dates.
Yes, meeting.
So 85 Monday ಅಲ್ವಾ? Monday. Thank you, sir. ಅಷ್ಟಲ್ಲಿದೆ. ಕೇಸ್ ನಂಬರ್ ಹೇಳ 26321 of 25. 26321 of 25. ಇದು ನಾಳೆ ಬಿಟ್ಟು 26321 ಲಿಸ್ಟ್ ಆನ್ 15/12/25. ಸರ್ ಒಂದೇ ಆಯ್ತಲ್ಲ.